Serial number 1.
सर मैं हियरिंग पार्टी 54 नंबर है सर।
हियरिंग पार्टी 64 नोट करिए।
54
सर मेरा 605 है।
Serial number 1.
सर इसको नेक्स्ट वीक मिलेगा।
Opening with the prayer of adjournment. No,
पर्सनल
declined.
डिफिकल्टीज है जेंट्स साहब,
No, no.
पर्सनल डिफिकल्टीज है सर।
Declined. Opening of the session with the prayer of adjournment, not happy thing.
कल के लिए ले ले, कल कर ले सर, कल के लिए कर ले।
Still it is an adjournment.
सर उनको पर्सनल डिफिकल्टीज है जेंट्स साहब, इसलिए आए नहीं सर।
Okay, as prayed by Shri
मनोज कुशवाहा।
Manoj Kushwaha, list in the next week.
मचो बस।
Serial number 2.
Your Lordship, this is fourth application for suspension of sentence.
Any previous decided on merits?
Your Lordship.
When?
First was decided on merit
On?
9/7/2019 से ऑर्डर 9/7/2000। Then after
Was decided by single
yes,
bench?
Lordship, this in this case, Lordship, 10 years conviction has been granted. By the,
Why it has come now by before DB? It's
there is state has challenged this appeal.
because of connected matter.
Therefore, this.
And how much is the custody?
Half of the sentence has been completed. Actually, today, 5 years, 1 month, and 5 days.
And total sentence is?
Total sentence is 10 years.
Custody report है आपके पास?
नो
Custody report मंगा लीजिए, next week में रखते हैं।
Your Lordship, I have submitted in custody report on earlier application. इसमें इसके साथ नहीं।
What is the name of appellant? Appellant का नाम क्या है?
Appeal Deepak.
तो ये have you seen there is a provision in the CRPC that in such cases can be heard out of turn basis? Have you seen any provision in the CRPC that this matter can be heard on out of turn basis?
I have to see that.
You examine it, you are keeping it tomorrow.
Yes, sir.
लेकिन learned counsel for there is a provision, इनको दीजिए 374 दीजिए मिस्टर धांडे। नेक्स्ट वीक फाइनल हियरिंग में
374 पार्ट
सीआरपीसी है आपके पास?
Yes, sir.
देखिए 374 में कोई प्रोविजन है सेक्सुअल असॉल्ट के केसेस में? 376 में आउट ऑफ टर्न हियरिंग का कोई टाइम लिमिट है प्रिस्क्राइब्ड?
$374
374
दो सिद्धि में अपील।
सबसेक्शन
कोई व्यक्ति जो उच्च न्यायालय द्वारा आधारित अधिकारिता को प्रयोग करने के लिए विचारणों के दोष सिद्ध किया गया है उच्चतम न्यायालय द्वारा अपील में, कोई व्यक्ति जो सेशन न्यायाधीश एंड उपधारा 2 में ऐसा जैसा उपबंधित है उसके सिवाय कोई
जो रेलेवेंट हो पड़ी ना, सबसेक्शन 4 देखिए। कोई समय सीमा है हाईकोर्ट के लिए कि इसको इतने समय में डिसाइड करना चाहिए? चलिए देख के रखिए, अभी पास ओवर
6 माह के अवधि में डिसाइड करें।
कौन सा सेक्शन है?
4 नंबर
लिखिए श्री परमानंद साहू फॉर द appellant is such and such in view of section 374 bracket में 4 of CRPC, learned counsel for appellant prays for final hearing of this matter at an early date, but more so when appellant has undergone more of half of the actual sentence, the prayer allowed. In absence of opposition, prayer allowed, list this matter for final hearing in the week commencing 3rd of July 23. Paper book be prepared, bracket mein if not already prepared. In view of this order, IAS such and such stands disposed of.
Your Lordship, my prayer, Your Lordship, on the earlier date, order dated
कोर्ट ने कहा था आधा सेंटेंस होने के बाद आप आइए लगा सकते हैं. आपका फाइनल सुनने को कोर्ट तैयार है. 3 जुलाई को आप तैयार होके आइए. मेंशन करिए अगर नीचे है नंबर तो विल हियर यू.
सीरियल नंबर 3. त्रिभुवन मिश्रा.
इस पे आइए था उनका टेम्परेरी बेल का इन्फेक्शस हो चुका है, मैरिज हो चुकी है.
नन फॉर द एपेलेंट. किस पर्पस के लिए था ये?
फॉर द पर्पस ऑफ द मैरिज ऑफ द.
कब थी मैरिज, कब थी?
6 और 7/6/2023 से 11/6/2023.
लेकिन नन फॉर द एपेलेंट श्री such and such informed, government council informed that IA number 10734 of 23 for temporary suspension of sentence has rendered infructuous. Prayer, in view of this order, IA such and such stands disposed of.
सीरियल नंबर 4.
My lord, this is the second application for suspension of sentence, my lord. First one was withdrawn, my lord.
Sole appellant.
There were 3 applicants, my lord. Yes, right now this is the sole applicant. There were 3 accused in the present matter. 1 was acquitted, 2 was convicted, my lord.
Yes. What is your role? Kindly tell us the story.
My lord.
Para 2.
अभियोजन घटना का सारांश में इस प्रकार है कि दिनांक 2/3/2017 को ग्राम तुनिया सालीवाड़ा का ग्राम कोटेवार मोतियाला छड़िया में पुलिस चौकी बरगी नगर पहुंचने पर प्रथम सूचना रिपोर्ट के ग्राम तुनिया सालीवाड़ा रोड किनारे होकर खेत की तरफ एक आदमी मरा हुआ पड़ा था. वहां लाल रंग की चौकड़ी शर्ट, जीन्स की नाली, नीला पैंट पहने हुआ था, जिसकी उम्र 100 थी. सिर से खून निकल रहा था. उक्त रिपोर्ट पर पुलिस द्वारा मर्ग कायमी पंजीकृत कर पंचनामा कार्रवाई कर असल मर्ग क्रमांक 100 जोफी कैमियो मामला जांच में लिया गया. जांच के दौरान मृतक के पास पाए गए सैमसंग कंपनी के मोबाइल के माध्यम से फोन लगाकर वारसानों को जानकारी दी गई, जिसमें देवी सिंह पटेल अपने अन्य रिश्तेदारों के साथ चौकी बरगी थाने पहुंचकर पहचान कृष्ण कुमार गुड्डा के रूप में की गई. मर्ग जांच के दौरान पुलिस ने पाया कि मृतक के पास से इंटेक्स कंपनी का मोबाइल एवं अपाचे मोटरसाइकिल क्रमांक MP20 100 थी, जो कि घटनास्थल मौके पर नहीं थी. अन्य साक्ष्य के आधार पर अन्वेषण के दौरान पुलिस ने पाया कि किसी अज्ञात आरोपी ने लूट करके इरादे से प्राणघातक सिर में चोट पहुंचाने से लूट घातक की है, जिसके परिणाम स्वरूप गुड्डा और कृष्ण कुमार मृत्यु हो गई. My lord, this is a matter wherein the incident was informed by some Motilal Jharia to the police. The police registered a mark, and during the inquiry they called. There is no eyewitness to the entire case, my lord. The entire case of the
Sonu Patel has been exonerated.
yes,
What is the evidence against you?
my lord. Firstly, the entire case is based on memorandum given by the accused. The memorandum given by the accused are based on 2 things. First is the lathi, which the police has recovered from me, and second, mobile phone of the accused, which has been said that I have taken away the mobile phone. Now, my lord, I'll take directly, my lord, to the seizure done by the police.
Weapon is recovered, human blood is found on the
Yes,
weapon.
my lord, in that context, my lord, in 313, I have made just a formal denial regarding that, and the weapon which has been seized from me, that is a lathi, my lord, but there is no eyewitness to this effect.
The
Firstly,
blood stain.
blood, yes,
human-
I say that blood stains are definitely there, but
Human blood.
Human blood, my lord, is there, but in that context, my lord, directly the blood group is also not matched
Is
by
it
the police.
necessary? Is it necessary?
Is it? It is not necessary, my lord. I've gone through the Madhav judgment also of the Supreme Court. It is not necessary. I say, my lord, that this lathi has been recovered on the instance of another accused, and a statement given by accused cannot be treated against another accused. This is very well, my lord, laid down in
But
section.
it is recovered from your possession.
This was recovered from my possession, my lord. The lathi was recovered from my possession. The human blood was also found on the same lathi.
You have not given any explanation in 313.
In 313, my lord, I have given a formal denial to this, my lord. But as far as the lathi part is concerned, my lord, may kindly come down to the property seizure of this lathi, my lord. May kindly examine this
That is exhibit.
exhibit. I do not have the exhibit, my lord. The paper book is not.
First go through the record, then argue.
My lord, the paper book is not prepared in this.
Even cases where paper book is not prepared, people come with preparation or mention request, we'll direct the registry to prepare a
My
paper.
lord, I'll just.
If you are not ready, please ask for time.
This is-
Don't waste our time. If you are not ready, ask for time, we'll direct the registry to prepare a paper book.
I can argue the matter, my lord, in this. I am ready with it, but
If you are ready, then you should tell us which is that
Lord,
exhibit.
exhibit is to mark me. I have the charge sheet also, my lord, but not with the. Then in
Why
that
don't
case-
you go through the record, mark your documents and then argue? Because spread by she gets only less than the next week.
Serial number 5.
application for change of counsel. Change of counsel की application.
लिखिए none for the appellant श्री such and such IA number 10832 of 23 seeking permission to change the counsel supported by affidavit of appellant is taken up in absence of opposition. I is allowed. Appellant may engage a new counsel by filing wakalatnama.
5.1.
एक बार पासवर्ड कर दो.
Serial number 6.
My lord, this is second application under section 389.
Previous was decided on merits.
No, my lord, withdraw over the first application.
Yes.
My lord, please see the page number 15. अभियोजन की कहानी संक्षेप में इस प्रकार है कि दिनांक 10/8/2019 को अभियुक्ति द्वारा थाना में इस आशय की रिपोर्ट लेख कराई गई कि वह कक्षा 6 तक पढ़ी है और 15 दिन पहले चौक बाजार भोपाल में कपड़े की दुकान में काम करती है। उसने वहां से काम छोड़ दिया और घर पर ही रहती है। वह लल्ला और सागर को जानती है जो मोहल्ले में रहता है तथा उसके जीजा के साथ ट्रक
Are you pressing your application?
No, my lord.
Three,
Vijay Yadav.
Vijay Yadav, after arguing for some time, seeks to withdraw IA 2934 of 23. She such and such has no objection. IA is dismissed as withdrawn.
Serial number 5.1. 3. Yes, Rajput.
None for the appellant adjourned. None for the appellant, even in the passover round adjourned. Okay.
Serial number 1, top of the list.
Lordship, I'm praying withdrawal of this petition with the liberty to file a fresh, properly drafted petition. Your Honor.
Shri and Navtej Singh Rupra seeks to withdraw this petition with the liberty to file a properly constituted petition. Shri Dhande GA has no objection. Petition is dismissed as withdrawn with the liberty prayed for.
Oblige, Your Lordship.
Serial number 2 along with connected case.
नंबर 2 में चेंज ऑफ काउंसिल है वालों 2.1 I filed change in council mallet
2 is listed suspension.
Yes, suspension, my suspension.
2.1 में लिखिएगा श्री none for the appellant श्री Dhande for the state IA number 11941 of 23 seeking permission to change the council supported by affidavit of appellant himself
yes my lord he was on parole
is taken up and for the reasons stated therein allowed appellant may engage a new counsel by filing वकालतनामा. आप बताइए Mr. VP Singh.
Yes, my lord. This, my lord, this is the fifth bail application, my lord. This is the fifth bail application.
Fifth.
Yes, my lord.
Any previous decided on merits?
1 मिलर 18/9/2017 is withdrawn. 11/5/2018 allow for the temporary bail and 6/1/2021 is withdrawn. 25/2/2022 is withdrawn. No,
Any decided on
no.
merits? Sole appellant.
Yes, there is appeal में there are 2 accused person in this case, my lord. One accused person, appellant number 2, Ramu. Ramu is released on bail by this court 23/2/2023, my lord.
Are you claiming on parity?
Yes, my lord. Yes. Judgment of para 43.
23/2/23.
Yes, my lord. 23/2/23.
उसके बाद तो आपने फिर विड्रॉ कर लिए का ये 23/2/23.
Yes, my lord.
Just a Presently, we are concerned with P. Kumar.
P. Kumar. Appellant number 1. And judgment of para 40 of the judgment, 43 of the judgment.
43.
Yes, my lord.
हमने इस टॉम पे बेल दी है कि इसका रोल से इतना था कि मोटरसाइकिल स्टार्ट करके खड़ा होता है असॉल्ट वगैरह करके। तो काम को ना बीच में अपनी मोटरसाइकिल स्टार्ट किया appears to be same Likesh did it. Shri VP Singh for the appellant number 1 Shri such and such heard on IA number 5913 of 23 for suspension of sentence arising out of such and such. So learned counsel for this appellant by taking this court to the prosecution story submits that the appellant did not assault the deceased person, that he was standing on he was sitting on a motorcycle and for similar role, this court was kind enough in suspending the remaining jail sentence of similarly situated co-accused persons Ram Kumar, क्या नाम है?
Yes, my lord. Ram Kumar.
Ramu alias Ram Kumar on 23/2/23. So thus, considering the aforesaid limited role and principles of parity, the remaining jail sentence of this appellant may be suspended. The prayer is opposed by Shri Dhande, learned GA, but he did not dispute the he did not rebut the argument relating to parity. So considering the aforesaid and finding given by court below in para 43 of impugned judgment, we deem it proper to grant benefit of parity. Resultantly, ना जितने की बेल उसको दी थी कितने
Yes,
30,000 सेम बेल सेम ऑर्डर देख
Oh, yes,
लीजिए तारीख उसको लगाई होगी
obliged.
Serial number 3.
Yes.
Okay.
Submission of 82620 and nothing. 72 to 10 years. As per prosecution, still not that as per para 3 लड़कों
Yes.
अभियोग मामला संशय इस प्रकार है कि शिकायतकर्ता बालिका का पिता ग्राम बोरवा थाना खगरान जिला बुरहानपुर का निवासी है। दिनांक 9/4/2018 को वह बच्चे से खाना खाकर गर्मी होने से घर के बाहर आंगन में सो गए थे। दिनांक 10/4/2018 को सुबह देखा तो लड़की अवलोकी बालिका नहीं दिखी। अतः उसने अज्ञात व्यक्ति द्वारा बालिका को भाला फुसला कर भगा ले जाने की सूचना 20/4/2018 को पुलिस को दी, जिसके आधार पर थाना खगरान जिला बुरहानपुर और प्रथम सूचना रिपोर्ट पदर्थ 7 लेखबत अपराध क्रमांक 87/18 अंतर्गत धारा 363 आईपीसी गुम इंसान सूचना श्रवण पंजीबद्ध किया गया। अन्वेषण के दौरान निर्मित किया गया दिनांक 17/5/18 को बालिका को अभियुक्त सुनील के कब्जे से बरामद कर पंचनामा निर्मित किया गया। बालिका की जानकारी दी कि अभियुक्त ने उसे 9/4/2018 की रात में शादी का झांसा देकर मोटरसाइकिल से होशंगाबाद ले गया। वहां रात में बस स्टैंड पर रुके।
Matlesh party after arguing for some time seeks to withdraw IA number such and such. She such and such has no objection. IA is dismissed as withdrawn.
Serial number 4.
इसमें 7 days time for serve the victim के लिए समय चाहिए।
Let the victim is served 7 days time to serve the victim.
Objection has been filed.
My lord, strictly the victim will be served in the next week, my lords. My lord had ordered for order was of 25th March, my lords.
List on next Wednesday.
When next day, Wednesday.
Next Wednesday.
Yes.
Serial number 5. Prasanth Pandey.
My lord, 10 days time for filing the objection.
None for the appellant. 10 days time to file objection. Next.
And also for serve the victim. 7.
10 days time to serve the victim and objection both.
Serial number 6 along with connected case.
Who is in the connected case?
6.1, 6 order for question of maintenance.
Two CRAs are filed.
Yes.
Office has raised an objection about maintenance.
Office has raised the objection. The father of the appellant is present before this honorable court. And due to misunderstanding, the another appeal has been filed, including the appellant Gabbasi, while the another learned counsel
one
had
appellant or-
adding it only for two
There is
appellants.
one appellant or more than one appellant?
नहीं, ये हमारे में तो सिर्फ एक ही है, बाकी और दो है सर.
हाँ, तो उस ये जो वन है ये दोनों में कॉमन है.
हाँ सर
गब्बासी
जी.
प्रेजेंट इज, आप कोई एफिडेविट फाइल कराइए, कुछ कराइए. विल नॉट रिकॉर्ड एनीबॉडीज एविडेंस.
हाँ ठीक है सर.
लिखिए she's as spread by Shri Sushil Tiwari list in the next week to enable him to seek instructions and do the needful.
Sir.
Serial number 7.
On the question of maintainability. Possible. Possible.
Serial number 8.
But the second election, Lordship. He's in since General Lordship in 13/4/2011 से Lordship.
Previous decided on merits.
No Lordship. Withdrawn Lordship because liberty Lordship to argue the case on the merit Lordship and final.
Do you have the paper book with you?
No Lordship.
Would you like to argue armed with the paper book? Then we'll keep it in the next week and provide you a paper book.
Lordship. Next.
लिखिए है कॉपी है एक्स्ट्रा. लिखिए copy of paper book is supplied to Shri Parikh, learned counsel for appellant, as spread list in the next week.
Lordship, by the time the objection can be granted 10 days.
Copy अभी objection नहीं है.
नहीं.
Objection be filed in the meantime.
Lordship.
Serial number 9.
Lordship, this is third application for suspension of sentence, Lordship, and he is in custody since 17/6/2011, almost 12 years custody period.
Any previous decided on
No,
merits?
Lordship.
Yes, please tell us. Shagan.
Lordship, it may be heard finally. It may be heard finally, I am requesting.
देखिए श्री, you are in custody since
17/6/2011, 12 साल हुए.
Shri Pagwar submits that appellant is in custody from June 11, and in view of period of custody, this matter may be heard finally on out of turn basis. Shri Dhande has no objection. Accordingly, list this matter for final hearing in the week commencing 10th of July 23. Paper book मिल गई है.
मिल गई. Oh, bless.
In view of this order, IA number 4813 of 23 stands disposed of.
Oh, bless.
Serial number 10.
मतलब 10 days time for filing.
None for the appellant, 10 days time to file objection.
Serial number 11.
Objection फाइल हो गया है सर.
Copy दे
और
दीजिए.
सर इसमें 8/12/22 को आईए रिजेक्टेड लिस्ट फॉर फाइनल हियरिंग का ऑर्डर.
ये वाली IA रिजेक्ट हुई है क्या?
नहीं, ये दूसरी आई है.
इन्हें फिर लगा
उसमें
दी.
लिस्ट फॉर फाइनल हियरिंग का ही ऑर्डर सर.
फाइनल हियरिंग में लगाते हैं. 2012 का मैटर है मैडम.
माय लॉर्ड, एक बार वो बेल के लिए कराना चाहते हैं. बेल के लिए एक बार आर्गू.
कोर्ट ने रिजेक्ट कर दिया आपकी मेरिट पे और ये कह दिया फाइनल हियरिंग में लगाइए. कोर्ट फाइनल हियरिंग करने को तैयार है, आप तैयार नहीं है फाइनल हियरिंग के लिए.
पार्टी तैयार नहीं है तो मतलब वो तैयार नहीं है. अभी बोल रहे थे कि एक बार बेल के लिए.
नहीं, उनके तैयार होने से थोड़ी होगा. कोर्ट ने आपकी मेरिट पे रिजेक्ट कर दी है अभी 22 में. और कहा है
ये माय लॉर्ड वो मेरिट पे नहीं है.
नहीं, आईए रिजेक्टेड लिस्ट फॉर फाइनल हियरिंग के लिए 2012 का मैटर
डिस्पोज कर दिए थे माय लॉर्ड. वो 10 ईयर के लिए माय लॉर्ड लगाया था उसमें, तो डिस्पोज कर दिए थे.
तो आप बहस करिए, मेरिट पे बहस करिए.
माय लॉर्ड एक टाइम दे दे, नेक्स्ट टाइम दे.
आइए पर बहस करिए ना. अगर आप सस्पेंशन पे तैयार हो तो बहस करिए.
आज प्रिपेयर नहीं है माय लॉर्ड. आज ऑब्जेक्शन के लिए था तो आज एक टाइम दे दे माय लॉर्ड. 1 वीक 10.
इसमें ऑलरेडी नेक्स्ट वीक में फाइनल हियरिंग का ऑर्डर कर दिया था 8/12 को.
8/12 को.
उसके बाद आप आए नहीं होंगे इसलिए एडजन हो गया. यस,
माय लॉर्ड वो हट गया.
नो, वी आर नॉट इंक्लाइंड इन सच केसेस. आपकी रिक्वेस्ट मानकर अगले ही हफ्ते फाइनल हियरिंग में रख दिया। आप फाइनल हियरिंग में आए नहीं, एडजर्न हो गया।
नहीं, एडजॉर्न हो गया था माय लॉर्ड।
इसलिए कि आप आए नहीं, नन करके एडजर्न हुआ, नन फॉर द एपेलेंट 12/1/23 को
जी एडजॉर्न हो गया था।
लिखे लर्नेड काउंसिल फॉर द एपेलेंट सबमिट्स
1 वीक टाइम दे
No,
दिया।
will not grant you time for IA. Learned Counsel for Appellant prays for time to argue IA number 9772 of 23 for suspension of sentence. Shri Dhande drew our attention to court order dated 8/12/22, wherein court directed for listing this matter for final hearing in the next week of the week of 8/12/22. Thereafter, nobody appeared for appellant and therefore matter was adjourned on 12/1/23. When court is keen to, when court fixed the matter for final hearing, it is expected that appellant will argue the matter finally and for this purpose list this matter for final hearing in the week commencing
माय लॉर्ड, एक आपसे निवेदन थी कि
3rd of July 23. In view of this order, IA number such and such stands disposed of. Next.
Serial number 12.
Default is, some default is there.
2 days time may be given to cure the.
2 days time. Okay, as prayed by Shri Tiwari, 3 days time is granted to cure default. List thereafter. Next.
Serial number 13.
10 days time for filing the objection.
10 days time to file objection. Next.
Serial number 14.
Also, this is the fifth bail application.
Any previous
Also,
decided on merits?
Also, 2 applications, one was decided on 26/6/2013 and 19/12/2013. They were dismissed on merits. Also, the other application was withdrawn on 6/8/2020. Also, at that time, a liberty was granted that 10 years imprisonment has not been completed by the appellant. Also, at present, he has completed 10 years of imprisonment.
He is in custody. Sir.
He is in custody since 6/11/2012. 6/11/2011.
Do you have any custody
Lordship.
report?
Lordship.
Court has given any finding about your custody? Sometimes court.
Also,
gives
arrest
a-
memo is there. Arrest memo is of 6/11/2011. Also, the incident is of 28th of October 2011.
Keep this matter for final hearing the next month. You argue it finally.
Also, next week. Also, here
This week, we may have the pressure of fresh motion work.
Also,
We will keep it in the first week of July. Like Shri,
paper book may kindly be done.
right, Shri
Kunal Dubey.
Kunal Dubey for the appellant submits that appellant has undergone actual sentence of more than a decade and therefore matter may be finally heard on an out of turn basis. Shri such and such has no objection. List this matter for final hearing in the week commencing 3rd of July 23. Paper book be prepared. In view of this order, IA such and such stands disposed of.
Obliged.
Suspension वाली application देख लीजिएगा court list में.
Serial number 15.
15 10 days time for filing objection.
10 days time to file objection. Next.
Serial number 16. R. Tiwari.
Pass over.
Serial number 17.
17 is 10 days time filing objection.
10 days time to file objection.
Serial number 18.
Is it first application?
Yes, my lord.
Yes, please.
My lord, घटना दिनांक से अभी तक अभियुक्त को कोई जमानत का लाभ नहीं मिला। घर की स्थिति बहुत दयनीय है। घर में कमाने वाला ओनली 1 मेंबर।
ठीक है, वो गुण दोषों पर भी तो कुछ बताइए। ये तो
यस माय लॉर्ड,
ये सहानुभूति से जुड़ा हुआ प्रश्न है।
इसमें पैरा 26 में ऑर्डर
क्या मेरिट पे तो बताइए, व्हाट इज योर केस?
इसमें पैरा
पैरा
26 में माय लॉर्ड है अभियोजन की ओर से अनावश्यक डॉक्टर के एविडेंस आए हैं।
पैरा 2 पढ़िए पहले प्रकरण की।
अभियोजन की ओर से अनाविधक साथी डॉक्टर सुमन सिंह के कथन कराए गए, जिसका शपथ पत्र पे यह कहना है कि दिनांक
पैरा 2 पढ़िए ना, प्रकरण की पहले तथ्यात्मक पृष्ठभूमि क्या है ये तो बताइए, फिर एविडेंस पर आइए।
मैं-
पैरा 2 ऑफ जजमेंट पर अभियोजन का कथन इस प्रकार है।
Yes. अभियोजन फरियादी अमर सिंह द्वारा थाना मंडी में आरक्षण रिपोर्ट दर्ज कराई दिनांक 12 को रात्रि में लगभग 8 बजे।
9 बजे लिखा, आप 8 कहाँ से पढ़ रहे
9
हैं?
बजे मतलब खाना खाकर जब घर के बाहर घूम रहा था तब लक्ष्मी नारायण घर के तरफ से चिल्ला चोट की आवाज आई थी और एक व्यक्ति गाड़ी गुप्तार करता हुआ मोटरसाइकिल से चौपाल तरफ चला गया। थोड़ी देर बाद वह व्यक्ति मोटरसाइकिल से वापस आया। इतने में लक्ष्मी नारायण की पत्नी छायाबाई चिल्लाई बचाओ, तो वह कैलाश और राजेश दौड़कर गए तो देखा कि लक्ष्मी नारायण को उसका साड़ू अभियुक्त है राकेश बोल रहा था कि इसने उसकी औरत को भड़काया है, इसलिए बैतूल चली गई और अभियुक्त ने जान से मारने की नियत से लक्ष्मी नारायण के दाहिने तरफ पसली के नीचे और बाएं तरफ सीने में चाकू से मारा। अनाज सिंह ने अभियुक्त के चाकू छुड़ाया और वहीं फेंक दिया। उसी समय काफी लोग आ गए जिन्होंने घटना देखी और लक्ष्मी नारायण को जिस अस्पताल सीहोर लाया गया। उक्त रिपोर्ट से थाना मंडी में अपराध 285/15 कथन कायम किया गया, जिसके आधार पर प्रदर्शन P1 का प्रथम सूचना रिपोर्ट पंजीबद्ध की गई। जिला अस्पताल सीहोर में दिनांक 2/9/2015 को लक्ष्मी नारायण के इलाज के दौरान मृत्यु हो गई।
छायाबाई ने बोला आपके अगेंस्ट में कोर्ट में? ये तो आप रिलेटिव हैं, साड़ू हैं आप।
माइलॉर्ड
छायाबाई डिपोज
पैरा 26 में डॉक्टर के एविडेंस आए हैं, उसमें ऐसा कोई गंभीर ग्रेवियस इंजरी नहीं थी उसको।
व्हाट इज द कॉज ऑफ डेथ?
और उसको उसके बाद में उसकी घर में लाए हैं, उसके बाद में उसकी डेथ हुई है।
व्हाट इज द कॉज ऑफ डेथ एज पर ऑटोप्सी रिपोर्ट?
काइंडली सी पैरा 26 है।
ऑटोप्सी रिपोर्ट के हिसाब से कॉज ऑफ डेथ क्या है? पोस्टमार्टम रिपोर्ट के हिसाब से कॉज ऑफ डेथ क्या है?
डॉक्टर सिंह सुमन के कथन कराए
You decided to avoid our question. This is thrice we have asked a very relevant question. What is the cause of death? You are not answering it.
9 to 11. Para 9 to 11.
अनाविदक्ष प्रदर्श P3 में अवलोकन से यह ज्ञात है कि चाकू के हमले के कारण मृतक की मृत्यु होने का उल्लेख प्रदर्श P3 में है। अनावेदक साक्षी अश्विनी कुमार नेगी का यह कहना है कि उसने आवेदन लिखकर स्व परीक्षण हेतु जिला चिकित्सालय भेजा था। स्व परीक्षण किए जाने वाले अनावेदक साक्षी डॉक्टर नवीन कुमार का शपथ में यह कहना है कि दिनांक 2/9/2015 को मेडिकल ऑफिसर के पद पर जिला चिकित्सालय सीहोर में पदस्थ था। उक्त दिनांक को आरक्षक 182 महेंद्र कुमार थाना मंडी सीहोर द्वारा लक्ष्मी नारायण के स्व परीक्षण हेतु आवेदन पेश किया गया। स्व परीक्षण किए जाने पर शव को ग्राह्य परीक्षण में घोंपा हुआ घाव इंटीरियर ऑस्पेक्टेड सामने की तरफ बाईं तरफ छाती में चौथी पसली पर, जिसका आकार 3x2 सेंटीमीटर था। यह चोट त्वचा एवं मसल्स के काटते हुए फेफड़े के अंदर तक, फेफड़े के अंदर इंटीरियर लेटरल थी। यह चोट हृदय के अंदर तक भी जो तिरछी ऊपर की ओर थी, जिसमें लगभग 700
Yes, we have gone through this paragraph. That is not the answer of our query. ये न्यायालय द्वारा पूछे गए प्रश्न का उत्तर नहीं है और 3 बार पूछे गए प्रश्न को आपने उत्तर देना उसको उचित नहीं समझा। एक प्रासंगिक प्रश्न को अगर आप अवॉइड करेंगे कैसे रिलीफ मिलेगी आपको?
चाकू करने के लिए हथियार से आई।
Yes, anything else, Mr. Counsel?
डॉक्टर के एविडेंस से MLC रिपोर्ट में तो ऐसा कुछ नहीं आया माय लॉर्ड।
Yes, we have seen that. Although you have not assisted us, but we ourselves could lay our hands on the relevant paragraph. Anything else? Last line of para 9.
पेट के अंदर अधपचा घाव था, यकृत, प्लीहा और गुर्दा तेल थे। अन्य साक्षी का यह भी कहना है कि उसके मतानुसार मृतक की मृत्यु हृदय और फेफड़े से हुए अत्यधिक रक्तस्राव के कारण हुई। हेमराइज उत्पन्न शौक से भी हुई, जो खतरनाक
हत्यात्मक प्रकृति की थी। Yes, anything else, Mr. Counsel?
But my lord, उससे की सलाह दी थी भारतीय ने सक्सेसवादी के प्रदर्शन बट प्रदर्शन P70 और प्रदर्शन P18 में ऐसा उसका नहीं आया है एविडेंस, डॉक्टर ने जो दिया है।
That's all. Anything else? कुछ और तर्क करना चाहते हैं?
अभियोजन के अनावी साक्षी डॉक्टर धर्मेंद्र सिंह सुमन के कथन कराए गए थे, जिसका शपथ पर यह कहना है कि दिनांक 1/9/2015 को पुलिस आरक्षक महेंद्र थाना मंडी में परीक्षण हेतु लिए गए अभियुक्त राकेश पिता कमल सिंह के डॉक्टरी परीक्षण किया गया था। परीक्षण के दौरान अभियुक्त पूर्ण होश में था। उसके शरीर पर सिर के वर्टेक्स तथा सीधे हाथ में अंगूठे के निचले भाग पर एक कटा हुआ घाव, बाएं हाथ की कोहनी में, बाएं पैर की पिंडली और खरोंच में सूजन पाई थी। अनान्वेष साक्षी 12 का यह भी कहना है कि उक्त चोट से एक्सरे की सलाह दी थी तथा आहत को भर्ती किया गया था। अनान्वेष साक्षी 12 द्वारा दी गई रिपोर्ट प्रदर्शन P17 प्रमाणित की गई एवं डिस्चार्ज टिकट प्रदर्शन P18 के रूप में प्रमाणित किया गया। डिस्चार्ज टिकट प्रदर्शन P18 के अनुसार व्यक्ति दिनांक 1/9/2015 को भर्ती किया था। दिनांक 2/9/2015 को डिस्चार्ज के प्रतिपक्ष में गवाह ने स्वीकार किया कि जब आहत अस्पताल में लाया तो वह पूरे होश में था, निगरानी में रखा गया था, परंतु उसे कोई गंभीर परिस्थिति सिर में चोट के संबंध में नहीं पाई गई थी। अनावश्यक साक्षी 12 ने यह भी कथन किया कि आहत को पाई गई चोट समान परिस्थिति में मृत्यु कारित करने के लिए पर्याप्त नहीं थी।
ये किस विटनेस ने बोला है?
डॉक्टर ने बोला।
कौन सा डॉक्टर? PW क्या है?
प्रदर्शन P17 डॉक्टर सिंह सुमन का पैरा नंबर 26 है।
P17।
यस मैम,
P17
पैरा 26 में।
कितनी देर बाद डेथ हुई है उसकी?
उसमें पैसे शरीर पर पाएगा चोट गंभीर संबंध में कोई नहीं थी। गवाह का यह भी कहना है कि सिर के चोट के संबंध में कोई गंभीर परिस्थिति नहीं पाए गए थे। अभियुक्त की ओर से शेष चोटों के गंभीर होने के संबंध में कोई प्रमाण प्रस्तुत नहीं किया गया है। उपरोक्त ब्यौरे से यह बताया कि अभियुक्त को गिरफ्तार किए जाने के समय उसके शरीर पर पाई गई चोट साधारण प्रकृति की थी।
ये जो आप एग्जिबिट पढ़ा रहे हैं ना, ये आपकी चोट के विषय में, ये आहत की मृतक की चोट के विषय में नहीं है। ये आपकी MLC है। बहुत सारी Counsel, this is not a good place to do homework.
पैरा 29 में भी दिया है माय लॉर्ड कि ऐसा कोई एविडेंस नहीं आया नीचे पैरा 29 में तो लक्ष्मी नारायण ने तो वो किया है नीचे की।
पैरा 29 भी जो है वो अभियुक्त को चोट के बारे में है।
तक लक्ष्मी नारायण को उसके सिर में कुल्हाड़ी से मारी।
आप ये दोनों पैराग्राफ अपने को लगी गई चोट के बारे में पढ़ा रहे हैं। अब आप प्रश्न जो है वो मृतक को लगी चोट के बारे में है।
मतलब उसको जान से मारने का कोई नहीं था, लेकिन 8 साल से अभी जेल में है, थोड़ा उसको जमानत का लाभ मिल जाता मुझे।
Yes. 10 कंप्लीट हो जाने दीजिए, फिर रिन्यू कर लीजिएगा एप्लीकेशन. We'll dismiss it with the liberty to renew it after 10 years.
मतलब 10 साल कंप्यूटर उसके बाद दे देंगे.
मतलब घर में बालक की भी फ्रैक्चर हो गया है और घर की स्थिति ओनली उसकी
We
बाइक
are not inclined at this stage. Choice is yours. If you want, we'll give you liberty to renew it after 10 years, or we'll decide it on merits.
माँ की भी डेथ हो गई है, फादर भी बहुत दयनीय स्थिति में है, अभी मिल जाता उसको जमानत।
Have you decided to test our patience on the opening day? We have already expressed our view. You are not assisting us at all. And you are reading two paragraphs which are relating to the injury on accused and projecting it as an injury on the deceased, which amounts to misrepresentation.
इसको अभी 2 weeks के लिए अभी कर
We will not adjourn after forming view. Leakage. We will decide it on merits. Leakage Shri
प्रकाश कोरी
Prakash
कोरी
Kohli.
कोरी सर
Query for the appellant is such and such, heard on IA number
बेटा महिला
5
लिबर्टी
333 of 23 for suspension of sentence. After arguing for quite some time, learned counsel for appellant seeks to withdraw this IA with the liberty to renew it after undergoing 10 years actual sentence. The other side has no objection. IA is dismissed as withdrawn with the liberty prayed for.
Serial number 19.
Objection. Objection.
Objection has been filed.
दीजिए इनको कॉपी दे दीजिए. Copy of objection is supplied to appellant counsel. कब करेंगे मिस्टर?
Next week.
As spread list in the next week.
Serial number 20.
Objection. इसमें भी सर सेम है ऑब्जेक्शन सब.
20 में मिस्टर दीपक सिंह है क्या? ऑब्जेक्टर है.
बताओ आपको
नेक्स्ट वीक कर दीजिए.
मालूम प्लीज
Serial number 21.
ऑब्जेक्शन इज अवेटेड ऑब्जेक्शन इज अवेटेड
21 objection has been filed.
कॉपी दीजिए.
जी
नेक्स्ट वीक
नेक्स्ट वीक मालूम
सेम ऑर्डर.
Serial number 22.
Objection has been filed.
नेक्स्ट वीक सेम ऑर्डर. सप्लाई करिए ऑब्जेक्शन कॉपी सब.
Serial number 23.
Objection received.
Yes. Victim is served.
जी सर.
Yes, Mr. Das.
My lord, sentence awarded, my lord, 376A, read with section B, and 376(2)L, 376(2)M for all in imprisonment RI for life till death. And PASCO is also there, my lord.
Yes.
Now, my lord, mother is PW1, my lord.
You just tell us the story before coming
The
to.
story is, my lord, that 25/4/2018 की घटना है.
Only read para 4.
Yes. Of judgment.
Yes. That will show us the factual backdrop.
अभियोजन पक्ष का संक्षेप इस प्रकार है कि रम्मी रजनी PW1 जो कि प्रार्थी पीड़िता की मां है, उन्होंने दिनांक 26/4/18 को थाना सोयनसो में एक संबोधित एक लिखित आवेदन दिया था कि वो बरबटपुर की रहने वाली, उसके 4 बच्चे हैं. बड़ी लड़की 11 वर्ष, छोटी लड़की 10 वर्ष, तीसरे नंबर की लड़की जो पीड़िता है उसकी उम्र सोयनसो है तथा लड़का 4 साल का है. दिनांक 25/4/18 को शाम करीब 6 बजे की घटना है. पीड़िता मोहल्ले में खेलने के लिए गई थी. उसने दूसरी लड़की तेजस को उसे ढूंढने के लिए भेजी. तेजस थोड़ी देर में
सीरियल नंबर 24।
अरे 25/4/18 से जेल में थोड़ा सा वो नोट
5 साल बता दिया आपने।
मोर देन 5 साल।
विल कंसिडर।
ग्रेटफुल।
सीरियल नंबर 24 रिपीट के नवेदिया।
Lord, this is first application in respect of appellant number 2. He has been convicted under section 102 with the aid of section 34 of the IPC. To the main assailant, who is appellant number 1, he had been convicted under section 102 of the IPC. As per the case of prosecution as reflecting para 3 of the impugn judgment, दिनांक 2/11/16 को आरक्षी के सो राम गोपाल यादव हु हैज बीन एग्जामिन्ड एज PW2 इस आशय की मौखिक रिपोर्ट की गई।
We are concerned with दंगल
नंबर 2। तो दिनांक को रात्रि लगभग 10 बजे बाद उसका भाई दीनदयाल इज द डिसीज खेत पर जा रहे थे, तब रास्ते में हरिराम एक बार दंगल रसीला खिलक के मिले। दीनदयाल ने आरोपीगण से कहा कि उसका खेत डूब जाने दो, फिर उसके खेत से तालाब का पानी निकालना। तभी पुरानी बुराई पर से आरोपीगण फरियादीगण को गालियां देने लगे, गाली देने से मना किया। तब हरिराम यादव ने कुल्हाड़ी की मूंद मारी जो फरियादी के भाई दीनदयाल के सिर पर लगी, इससे खून निकलने लगा। दंगल यादव दीनदयाल की लाठी से मारपीट करने लगा, जिससे उसे कई जगह चोटें आई। फरियादी रामगोपाल ने बीच बचाव किया तो उसे भी लात भूतों से मारपीट की। फिर उस मामला इनिशियली दर्ज हुआ 323, 294, 506 और 4 तारीख को 2 दिन बाद ड्यूरिंग ट्रीटमेंट ही डाइड। दीनदयाल डाइड। फिर 302 में चार्जशीट फाइल। The PW2 is the very relevant eyewitness. He is Ram Gopal. His court statement. मैं आरोपीगण को जानता हूँ। मृतक दीनदयाल बड़े भाई थे। घटना आज से PW2 इंजर्ड आई विटनेस।
Yes.
मैं आरोपीगण को जानता हूँ। दीनदयाल बड़े भाई थे। घटना 6 माह कार्तिक अगहन की है। रात के 9-10 बजे मैं और मेरे बड़े भाई खेत देखने गए थे। खेत में जैसे ही हम लोग बाहर गए तो हरिराम और दंगल मिले। हम लोगों ने उनसे कहा कि पानी सुबह निकाल लेना, हमें खेत भूले नहीं दो। तो बात पर से गालियां देने लगे। बड़े भाई ने उन्हें गाली देने से रोका तो हरिराम ने कुल्हाड़ी की मुदार मेरे भाई दीनदयाल को मारी, जो उन्हें सिर में माथे के पास, सिर के पीछे और अन्य जगह लगी। मैंने बीच बचाव किया तो दोनों आरोपीगण ने लाठी कुल्हाड़ी से मारा। मुझे नाक, पीठ, कंधा में चोट आई। चिल्लाया तो मेरी भाभी रानी, पत्नी राकेश, अवध, धीमन मौके पर आ गए। बीच बचाव किया, गालियां देते हुए भाग गए। निकलने पर से रोका तो जान से मार कर देंगे। उठाया, अस्पताल ले गए, रेफर किया। ग्वालियर अस्पताल रेफर कर दिया। ग्वालियर अस्पताल में मृत घोषित कर दिया गया।
He's an injured eyewitness.
हाँ,
He's an injured eyewitness.
इंजर्ड आई विटनेस है। नहीं कहता कि दंगल असल्टेड टू द डिसीज को केवल हरिराम ने कुल्हाड़ी से मारा। सेम इज सपोर्टिंग फ्रॉम एविडेंस ऑफ PW13 is the doctor who conducted the MLC and postmortem also. PW10
And he is in custody since
ये है 13/11/16 से।
इसमें पैरा 2 की लास्ट लाइन में कहता है मेरे भाई की मृत्यु पढ़िएगा। पैरा 2 की लास्ट लाइन पढ़िएगा।
पैरा 2 आप
सेम डिपोजिशन।
अच्छा, PW2 का मेरे भाई की मृत्यु मेरे भाई के आरोपीगण द्वारा कुल्हाड़ी लाठी से मारपीट कारण चोट कारण हुई। तो अब इसका MLC देखना है ना, केवल कुल्हाड़ी की।
कहने का आशय कि दंगल के बारे में भी बोल रहा है।
इसका कहने का आशय ये है कि इन्हें भी मारा था। वो करस्पॉन्डिंग इंजरीज नहीं करनी है। लोग दी PW10 डॉक्टर हु कंडक्टेड द MLC एंड पोस्टमार्टम रिपोर्ट। केवल 3 चोटें हैं और वो चोटें केवल कुल्हाड़ी की दिख रही।
करीब 6 साल रह लिए। Mr. Counsel, he is not the main accused, government counsel. He is not the main accused. He remained in custody for about 6 years.
बस सर इसके अलावा 2 आई विटनेस है, उन्होंने तुम्हारा कि लाठियों की चोट और 34
नहीं, वो तो बाद में आए उसके कहने के हिसाब से, जब
इसके
हमारे
अलावा
साथ
2 आई
Mr. Navaria, one should know where to stop. We are asking him, we are inclined, therefore we are asking him. Yes, he remained in custody for 6 years and he is not the main accused. Like Shri Navaria for the appellant number 2, Shri such and such, heard on IA number 17850 of 19 for suspension of sentence arising out of such and such. But by taking this court to the prosecution story, learned counsel for appellant submits that on 2/11/16, the injured witness Ram Gopal Yadav, bracket में PW2, lodged a written oral report in police station Palera that he, along with his brother Deen Dayal, bracket में deceased, were going towards his their agricultural field, but in between both the appellants stopped them and a quarrel had taken place. An exchange of heated arguments had taken place, which was followed by assault by both the appellants. Learned counsel for the appellant, by taking this court to the statement of PW2, submits that he mainly deposed against the main accused Hari Ram, who allegedly assaulted the deceased person by means of lathi. This appellant allegedly assaulted the injured eyewitness Ram Gopal Yadav. Appellant is in custody since
13/11/16.
13/11/16. The incident had taken place suddenly without there being any premeditation. No deadly weapon has been used. 3 injuries were found on the person of deceased, which became cause of death. The final hearing of this appeal is not possible in near future. Thus, remaining jail sentence of this appellant may be suspended. The prayer is opposed by Shri Arvind Singh. Considering the limited role of this appellant and without expressing any opinion on merits, we deem it proper to suspend the remaining jail sentence of this appellant. इनको 30,000 की जमानत कर दीजिए. Trial court अभी चालू है क्या बेटा? अंकला न्यायालय के लिंक कोर्ट चालू होगी, यहाँ कर देते हैं मेन कोर्ट. The appellant shall mark his presence before Sessions Court, Tikamgarh on 21st of August and further dates decided by the said court.
Serial number 25.
Objection.
Copy नहीं मिली.
There is supplied.
देखिए, copy of objection is supplied. As
10 days.
trade list after 10 days. 23 की फाइल दे दीजिए. 23. देखिए, श्री अरूप के दास for the appellant, Shri such and such for the state, heard on IA number 5178 of 23 for suspension of sentence arising out of such and such. As per prosecution story, a mentally challenged victim aged about 7 years was sexually assaulted by the appellant. Criticizing the findings, learned counsel for the appellant submits that spot map exhibit P3 shows that house of the appellant is just adjacent to the main road, and adjacent to that house, satsang, inverted commas, satsang was going on. Thus, such an incident in broad daylight is not possible. It is further submitted that mother and father of victim did not support the prosecution story. The MLC does not conclusively shows that any such sexual assault, rape had taken place. In addition, it is submitted that DNA report also does not support the case of prosecution. The prayer is opposed by Shri Arvind Singh. Next, the mother and father of victim gathered knowledge about the incident on the basis of information given by a child witness, Tejal. The statement of Tejal, PW 4, prima facie inspires confidence. Apart from this, the DNA profile shows that apart from this, DNA report is considered by court below in impugned judgment in para 27, which prima facie, in our opinion, is a plausible view. Considering the heinous nature of crime, at this stage, no case is made out for suspension of sentence. Thus, without expressing any conclusive opinion on merits, the IA is dismissed.
पैरा 26 है सर, वो DNA के बारे में जो
27 जहाँ है ना, 26 कर लीजिए.
Serial number 26.
Lordship, this is the same matter wherein Milord the appellant is.
Yes, today you are ready.
Yes.
If it is convenient, we'll keep it as a last matter so that it will take some time.
Yes.
And let other motion work is over. We'll devote time in the end. The last matter.
Serial number 27.
Yes, Topadhyay.
This is second application for suspension of sentence. Office first has been dismissed and withdrawn on 2/5/20.
On
3/10.
6.
3/10/2022.
Yes.
The conviction under section 304B for arrive for life, Lordship. Section 498 for 3 years and
This application is for which appellant?
Appellant number 2, 1 and 3 has been released on bail, Lordship. Number 2 is the husband of the deceased, Lordship.
Yes. What is the story?
The story is that, Lordship, as per para 3, Lordship, the date of incident 27/9/2015. थाना बरही में प्रधान आरक्षक के पद पर पदस्थ था। उस दिनांक को सूचना करता प्यारेलाल 45 गांव पड़िया बरही जिला सूचना दी कि उसका भतीजा बहू श्रीमती सुलोचना पति संतोष चौधरी 27 साल अपने घर में आग से जलकर दिनांक 27/9/2015 की सुबह 10 बजे जलकर फौत हो गई। Then the first information has been, the morgue has been registered.
How many days after marriage?
After Lordship, after 6 years.
Within 7 years.
Within 7 years. Under 7 years. Two children are there, Lordship.
Yes.
PW4, Lordship. Eyewitness in this case.
What is the cause of death?
Cause of death due to burn injury, Lordship. 80% burn injury has been found on the body of the deceased, Lordship, as per postmortem report.
And who informed the police?
Police, one uncle.
You were not at home?
No, father, husband and mother not at the time of the place of incident. They are going to other village for a death of his auntie.
Why court has on what basis court has convicted you?
Lordship, as per para number judgment para number 40. So 43. Page number 82 of paper book.
Yes.
पूर्व विश्लेषण से प्रकट होता कि मृतिका घटना दिनांक को अभियुक्त के साथ निवास कर रही थी। घटना के कुछ दिन पूर्व वह अपने मायके गई थी, जहां रो रही थी, कह रही थी कि उसके साथ मारपीट की गई है। 27/9/2015 के उपरांत मृतिका की मृत्यु जलने से हो गई थी। तब अभियुक्त गण पर यह भार था कि वे स्पष्ट करें कि मृतिका कब किन परिस्थितियों में निवास में जली, उसके पश्चात मृत पाई गई। अभियुक्त गण इस संबंध में स्पष्टीकरण दिए गए हमें संतोषप्रद नहीं है। इन दैट रीजन दे हैव convicted him.
There is a presumption or not?
Presumption.
If court has invoked presumption, what is wrong in that?
Lordship, I have said. PW4 में kindly we see who he is.
I have the paper book with you. PW4 page.
Page number, Lordship,
18.
18.
Yes. Yes.
Para number 1, Lordship, आरोपी संतोषी लल्ली वैशाली को जानता हूँ।
Who is this gentleman?
He is villager of that village, Lordship. आज से लगभग 2 वर्ष पूर्व की बात है। गणेश उत्सव के समय की बात है। 10 बजे दिन में दादू शर्मा के साथ आ रहा था तो देखा लल्ली चौधरी के घर से धुआं निकल रहा था। फिर रोड से देखे तो देखा कि लल्ली तो तेजी से आग बढ़ रही थी। मैंने दादू राम से कहा कि गांव में आग लग गई है और मैं लल्ली के घर पहुंचा। उसके बाद घर पहुंचा तो दरवाजा अंदर से लगा था। मैंने दरवाजे में धक्का दिया तो मैंने बड़ी तेजी से दरवाजे में लात मारी तो कमरे में आग लगी थी, सामान जल रहा था। मैंने वहीं पानी उठाकर कमरे में डाल दिया। फिर मैंने देखा कि मृतिका कमरे में जली पड़ी थी। मैंने पानी डालते समय अंदर घुसा, तभी देखा कि मृतिका सुलोचना जली पड़ी थी, वह मृत हो गई थी। उसी समय गांव के काफी लोग आ गए थे। वहां मौके पे झल्लू सिंह, दादूराम आ गए थे। मृतिका की पति और माँ के साथ अपनी मौसी के यहाँ गया था। घर में 2 बच्ची या खेत में काम करने गई थी। जब आग आधी बुझा दी गई थी तब संतोष के बाप लल्लू आ गए थे। मैं नहीं बता सकता कि मृतिका के घर में आग कैसे लग गई। मुझे नहीं मालूम कि आग किसने लगाई, नहीं पता ससुराल वाले अच्छे से रखते थे कि नहीं रखते थे। देन लॉर्डशिप, एलिगेशन ये लगाया गया है इस केस में, जो फादर हैं, मदर हैं और जो रिलेटिव्स हैं डिसीज के, उनका कहना है कि मोटरसाइकिल ना देने के कारण प्रताड़ित करते थे। ऐसा सिर्फ एक सिंगल एलिगेशन है, वो भी डाउरी डिमांड का नहीं था, सिर्फ मोटरसाइकिल का था, जो फादर, मदर और अदर रिलेटिव्स ने बताया था। तो इसी के पैरा 4 में भी आया है कि संतोष के पास पहले से मोटरसाइकिल थी, शादी होने से 2-3 साल पहले इस घटना के पहले से मोटरसाइकिल है। और फादर जो है PW1 है डिसीज के।
उन्होंने क्या बोला है
सर? उन्होंने PW1 जो है वो पेज नंबर 9 में है सर। मैं सो उनको जानता हूँ। सुलोचना मेरी पोती थी। आज से करीब 6 वर्ष पूर्व सुलोचना का विवाह प्ररिया के संतोष के साथ किया गया था। शादी के समय अभियुक्त लल्ली यानी फादर इन और संतोष मोटरसाइकिल की मांग करते थे। मैंने उनसे कहा था कि मेरी व्यवस्था नहीं है, जब व्यवस्था हो जाएगी तो दे दूंगा। इसके बाद सुलोचना विदा होकर चली गई थी। पहली रूसी विदाई मैंने दहेज के सभी सामान अपनी हैसियत के अनुसार दे दिए थे। सुलोचना मायके में ससुराल आना जाना रहता था। वह मायके आती जाती थी, बताती थी कि गाड़ी और पैसों की मांग के लिए लल्ली, संतोष, बेसखिया परेशान करते हैं। मैंने सुलोचना से कहा था कि अभी मेरे पास नहीं है, जब भी होंगे तो दे दूंगा। उसे समझा बुझाकर ससुराल भेज देता था। पिछली बार कजरिया के समय सुलोचना ससुराल में प्ररिया आई थी। मुझसे घर के सभी लोग, लल्ली, संतोष और बैसखिया ने गाड़ी व पैसे की मांग की थी। मैंने उनसे कहा था कि मेरे पास अभी व्यवस्था नहीं है, व्यवस्था हो जाएगी तो दे दूंगा। सुलोचना ससुराल वालों ने मेरे साथ नहीं भेजा था, तब मैंने कहा कि आप खुद भेज दो। सुलोचना को लेकर संतोष और बैसखिया आए थे। वे उसी दिन सुलोचना को छोड़कर चले गए थे। सुलोचना उस दिन रो रही थी, बताई कि मुझे मेरे ससुराल वाले परेशान करते हैं, उन्हें मोटरसाइकिल दे दो। मोटरसाइकिल न देने के कारण सुलोचना के साथ अभियुक्त मारपीट करते हैं। जन्माष्टमी में तक मायके में, इसके बाद ससुराल में जबरदस्ती ले गए थे। सुलोचना ससुराल नहीं जाना चाहती थी।
इसमें इसने कहा ना कि आपने उसने मोटरसाइकिल 25/8/15 को खरीदी थी।
जी, इसमें पैरा नंबर 7 में आया है स्पेसिफिक। 1 महीने पहले हमने दूसरी मोटरसाइकिल खरीदी थी। वो भी नहीं सर, पुरानी तो थी हमारे पास, ये दूसरी नई खरीदी थी। तो डिस्प्यूट वो जो बता रहे हैं वो आफ्टर डेथ ऑफ द डिसीज उन्होंने क्रिएट किया कि डिमांड ऑफ डाउरी लाने के लिए सिर्फ मोटरसाइकिल की।
उसके बाद मर्ग के बाद तुरंत बयान हुआ था
सर? मर्ग के तुरंत बाद नहीं, 3 दिन बाद हुए हैं।
उसमें क्या बोला था? 160
मर्ग के बयान तो नहीं थे हमारे पास। स्टेटमेंट में ये फर्स्ट टाइम आया था कि ये मोटरसाइकिल की मांग करते हैं।
नहीं 161 कोर्ट डायरी स्टेटमेंट में, केस डायरी स्टेटमेंट में क्या बोला?
केस डायरी वाले स्टेटमेंट नहीं है, क्योंकि वो एग्जिबिट ही नहीं हो पाए थे, ना उसमें पूछ पाए थे क्रॉस में, तो इसलिए।
देख के बहस करिए ना
जी,
क्योंकि अगर
जी।
ये आफ्टर थॉट
जी,
उसमें फिर कॉन्ट्ररी होगा या नहीं होगा।
जी, वो मैं देख।
Go through the record, then argue. Because Shashank Upadhyay, after arguing for some time, prays for time to go through the record and then argue the matter. Prayer allowed, list after 7 days. इसमें पेपर बुक में नहीं है 161?
नहीं, 161 तो है, 161 में तो वो डिमांड ऑफ मोटरसाइकिल आया है बस।
मर्ग नहीं है इसमें?
नहीं, मर्ग नहीं।
Serial number 28.
So I am praying for next week, Lord. So 313 के statement देखना है मुझे.
As prayed by Shri UN Pandey, list after a week next.
Serial number 29 along with connected case.
I am praying for a Passover.
Pass.
Serial number 30 along with connected case.
One thing is I am moving an application for release of my vehicle. इसमें ये लॉर्डशिप देयर वर 3 accused as per prosecution story. I was acquitted. Other 2 has preferred these 2 appeals. My application was
Where is
pending.
the finding about? Is there any finding about ownership of motorcycle?
My lord, last para में.
What is your name?
I am Devi Prasad.
Devi Lal.
Devi Singh Jaiswal. I was there were 3 accused. I was acquitted. लास्ट पैराग्राफ 114 में आया हुआ. There are 3 items, 4 items actually. One my mobile, 1000 rupees, SIM card and this vehicle.
पढ़िए कहाँ पर है?
ये प्रकरण में जब संपत्ति नकदी 3300 रुपए मोबाइल पर किसी भी आरोपी द्वारा अपना दावा प्रस्तुत नहीं किया गया, अतः जब्त मोबाइल के संबंध में उनके दावेदार विहित अवधि के विधि अनुसार आवेदन पेश कर न्यायालय प्राप्त करें. अन्यथा अपील अवधि पश्चात विहित अवधि समाप्त होने पर अपील न होने पर उन्हें विधि अनुसार नष्ट किया जाए तथा नकदी रुपए की अपील अवधि पश्चात अपील नहीं होने राजसात किया जाए. प्रकरण में जब्त वाहन टवेरा सो एंड सो व्हीकल नंबर के अंतरिम सुपुर्दगी पर होने पर विधेयक पर कोई सुपुर्दनामा संलग्न होना प्रकट नहीं है, अतः उक्त वाहन अपील अवधि पश्चात अपील नहीं होने पर रजिस्टर वाहन स्वामी को लौटाया जाए.
तो वो कहीं फाइंडिंग आई कि आप रजिस्टर वाहन स्वामी?
This vehicle was seized by the present intervener. Vehicle is registered owner is somebody else that has given me power of attorney. That is IA2 along with my record, along with my IA number 4654. And I also filed original bill of my mobile.
You are claiming a return of mobile and
vehicle and SIM card.
So you were one of the accused before?
I am one of the accused. These
you
4
did not claim that it's your mobile before court below?
My lord. Lord, so my season memo we seen. It has been seized. This article has been seized by the present intervener, my lord. This jeep was
court has given a finding कि मोबाइल पर किसी ने दावेदारी नहीं की.
लोअर कोर्ट में नहीं की थी, my lord. हम तो जेल में थे, फिर एक्विटेड हो गए. एक्विटेड के बाद उन्होंने कंडीशन डाल दी अगर अपील होती है उसके पश्चात ही दिया जाएगा गाड़ी.
But you are not the registered owner.
I am not the registered owner. Vehicle has been seized from the present intervener as per section 2 subsection 30. A person who is in possession of the vehicle is the owner of the vehicle. And in addition to that, Dr. I have filed IA number 4654 may be seen, my IA number, intervention application. I have filed registration certificate. Thereafter, Lord, I have filed.
Registration is in somebody else's name.
My lord.
So let him come and claim that.
He has given me power of attorney because this vehicle has been seized by the present intervener and mobile has been seized by the by my.
So what is the hesitation for the owner? Why can't he come and say that I want my vehicle back?
So as per section 2 subsection 30, my lord, the person which is vehicle has been seized is in possession is the owner of the vehicle.
Which law?
Section 2 subsection 30 of the Motor Vehicle Act. Second lordship, this vehicle has been seized by the present intervener. I was pleaded as a third accused. Thereafter, I was sent to jail.
But what is the hesitation? Why registered owner is not coming before us and saying?
He has given me, lordship. And so far as mobile is concerned, lordship, that is in my name. Mobile has been also seized by me. Even lordship, I am in possession of original registration.
रजिस्टर्ड ओनर के लिए ऑर्डर है उसमें
जी,
पावर ऑफ अटॉर्नी आपके नाम से है
जी,
तो आप ट्रायल कोर्ट से क्यों नहीं ले लेते यहाँ क्यों?
उसमें कंडीशन डाल दी ना, मतलब अपील होने पर पैरा 114 में पढ़ा
अपील होने के पश्चात होने पर
now this matter is subjudice before my lord.
एक्विटल की अपील कहाँ है? एक्विटल की अपील है क्या कोई?
नहीं एक्विटल, मैं तो एक्विटल हो गया, उसके खिलाफ स्टेट
इस पे शासन की अपील है क्या?
शासन ने अपील नहीं की। ये दो लिंक है
फाइनल हो गया?
जो कन्विक्टेड हुए हैं।
Please try to understand the question, what brother is asking.
That I am.
So far you are concerned, there is no appeal against you.
So my lord may grant me liberty to move an application before the
Okay,
London court below.
3.
आशीष रावत
Ashish Rawat seeks to withdraw IA number such and such, दो IA हैं इनकी देख लीजिएगा, with the liberty to approach the trial court for the same grievance. The other three such and such has no objection. IA is dismissed as withdrawn with the liberty paid.
लॉर्ड सीरियल नंबर 30 में लॉर्ड CRA नंबर 7609, इसमें ऑलरेडी आईए वांट ऑफ प्रोसिक्यूशन डिसमिस हो चुकी है, रॉन्गली फिर से वो लिस्टेड हो गया आईए पे।
कौन सा है क्या वो 7609 क्या है वो?
76 अपील है सर को एक्यूज्ड की कन्विक्शन की, उसमें ऑलरेडी आईए सस्पेंशन ऑफ सेंटेंस की लगी थी, वो वांट ऑफ प्रोसिक्यूशन में 27/3/2023 को डिसमिस हो चुकी है, वो रॉन्गली फिर से मेंशन हो गया आईए।
ये ऑर्डर अभी ये आपकी एप्लीकेशन किस में थी, इंटरवेंशन वगैरह?
आइटम नंबर 30 में, क्रिमिनल अपील 6899 में थी।
कब डिसमिस हो गई है?
नहीं हमारी आईए हमारा अपील नंबर है 7609,
उसमें कब डिसमिस हो गई है वो आई?
ये 27/3/2023 वांट ऑफ प्रोसिक्यूशन।
इसमें ना जो दो आईए मैंने आपसे कहा था ना, उसकी जगह आप सिर्फ एक आईए लिखिएगा, दैट इज 4654। नहीं, उस दिन जो डिसमिस हुई है ना वो आईए नंबर 16379 हुई है, सस्पेंशन ऑफ सेंटेंस।
30.1 7609 CRA नंबर।
अभी आप 30 कह रहे थे।
30.1 सर।
30 में कुछ नहीं लिखना है ना, 30 में इंटरवेंशन विड्रॉ हो गई बस, है ना। 30.1 में आईए नंबर 30.1 में लिखिएगा, आईए नंबर 16379 of 22 has already been dismissed by this court on 27/3/23। Next.
Serial number 31.
Actually, it may be taken next meeting.
As prayed by Shri Usmani list after 7 days. Next.
Serial number 32.
Maharaj, I'm seeking 4 weeks time to argue this matter.
Why you are not ready?
Maharaj, the senior has to argue the matter.
As prayed by Shri
Mayank Sharma, ma'am.
Mayank Sharma adjourned for 2 weeks.
Serial number 33.
Lordship, pray for 2 weeks.
Why you are not ready?
Lordship, my senior will handle.
Same order. है ना, रामानुज चौबे।
Serial number 34 along with connected case.
My lord, notice and objection awaited, my lord, the copy of the objection was sent to me.
Mr. Gupta,
Yes, Lordship, objection is filed, Lordship.
copy of objection
Copy of submission.
दीजिए, इनको दीजिए। Copy of objection is provided to Sri Madan Singh। कब करेंगे?
Next week, my lord.
As prayed, listen the next week with connected matter next.
Serial number 35.
Lordship, the copy of the objection is required to be provided to me.
Government,
Lordship, supplied.
same order.
I have also supplied, Lordship.
Actually, that has been supplied to Mr. Mitra, my lords. It has not been supplied to me. We are two advocates. In
आप
this,
इनसे ले लीजिए।
yes, no, I will.
That is an internal arrangement. As prayed, listen the next week.
Serial number 36.
First bail application, behalf of appealant number 2, my lord, Ashraful Nisa. Conviction under section 304B, 498A and 4 dowry. This bail application is filed only for appealant number 2, my lord.
No previous decided on merits?
No, this
Two
first-
is, what is the relation?
Appealant number 1 is husband, appealant number 2 is also mother-in-law of the deceased. The deceased, Fan Banu,
Is there any dying declaration?
no, ma'am. She got burned in house while cooking food as per the appealant, and as per the mother and father, she was burnt by the appealant. It was the husband who took her to the hospital. May I read the prosecution case from?
Yes, please.
Para 3.
Yes.
Para 3 abusing का
पैरा 3 ऑफ जजमेंट। अभियोजन का मामला संक्षेप में इस प्रकार के पुलिस थाना सिंहपुर में अस्पताल चौकी सतना से इस आशय की सूचना प्राप्त हुई कि मृतका इरफाना बानो को आग से जलाकर बताकर एवं नागोद अस्पताल से रेफर होकर 2/9/15 को चापाता पीएम कर जिला चिकित्सालय सतना मृत अवस्था में लाया गया था। शव को शवगृह में रख दिया गया। आवश्यक कार्रवाई हेतु सूचना प्राप्त हुई। The marriage has taken place on 24/4/2011, madam, and she died on 2/9/2015. After 4 years, 4 months of marriage, there were 2 children, madam, girl child. And present appellant, she is mother-in-law. As per FIR, my lord, initially incidents of 2/9/15. FIR was registered on 9/10/2015.
Incident is of
2/9/15, madam. Murg intimation was given to the police on 2/9/15. Incident of 2/9/15. FIR was registered on 9/10/15.
who lodged the FIR?
My lord, information was given by the husband to the doctors and the police. As per our submission, the Murg intimation is there, madam.
But who lodged the FIR?
Doctors send the information from the hospital to the police.
Yes.
She was brought by the husband, and husband also got burnt, but trying to save her, hands got burnt also.
Yes.
And
This
161
incident had taken place in the kitchen.
Madam?
This incident had taken place in the kitchen.
Yes, madam. In the house of the appellant.
The house means in the kitchen or in the bedroom?
Kitchen, madam. Yes.
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 Yes, please, Mr.
Madam. PW1 is Dr. Amar Singh, madam. Exhibit P1 is the PM report, in which paragraph 3, cause of death, madam. अभिमत हमारा डॉक्टर टीम की राय में मृतका की मृत्यु का कारण दर्द घुटना था जो जलने के कारण। PW2 Habib Khan, madam, is the father of the girl. In paragraph 15, madam, paragraph 15, he says, in paragraph 1 and 2, they have taken, उसमें कहा है कि सबने मारा पीटा ऐसा लगा, but no direct allegation against the appellant number 2.
So any injuries were found on the person of the deceased?
No, man. No.
Only burn injuries?
Burn. As per PW1 Dr. Malon?
No assault injury?
No. PW1 Dr. Amar Singh, who has done the PM, Malon. मृतक के शरीर में अकड़न थी, दाहिने काल में फिफलर लगा हुआ था, उसका पूरा शरीर जल, उसके पांव और हाथ पे पंजे भी थे, सिर्फ सर के बाल बचे हुए थे, सिर्फ मिट्टी तेल की बदबू आ रही थी। आंतरिक परीक्षण में पैरा 3 में अभिमत हमारी टीम की राय में मृतक की मृत्यु का कारण दम घुटना जो जलने के कारण था। पोस्टमार्टम से मृत्यु की अवधि 24 घंटे के अंदर की थी। PW2 is the father, Habib Khan. In paragraph 15,
you are in custody since?
He was granted anticipatory bail during the trial, Mala, appellant number 2, and she is in, from the date of the judgment 27 to 23.
Very recently. Yes.
And appellant number 2, the father, main is the husband, Mala, allegations again. Appellant number PW2, Mala, in paragraph PW2 paragraph 14, that's paragraph 15, Mala. PW2 father, paragraph 15, मेरा बयान पैराग्राफ 15 मिडिल ऑफ दैट, मेरा बयान 9/10/15 को नौगोद में हुआ था, मेरा बयान 21/9/15 को 9/10/15 मतलब द इंसिडेंट इज ऑफ डेट ऑफ इंसिडेंट इज 2/9/15, इसका बयान 9/10/15 को हुआ था, आफ्टर 1 month and 7 days अराउंड। पैराग्राफ 15 मिडिल ऑफ दैट, मेरा बयान दिनांक 9/10/15 को नागौद में हुआ था, मेरा बयान 21/9/15 को नहीं हुआ था, बट पुलिस डायरी में 21/9/15 का भी दिख रहा। पंचनामा आफ्टर 1 month 7 days। जो दूसरा वाला मेरा बयान 21/9 का भी बता रहा है, वो भी आफ्टर 13-14 डे। इंसिडेंट है 2/9/15 का। पंचनामा मतलब जो पंचनामा रिपोर्ट पंचनामा बना एग्जिबिट P3, इसमें सब लोग उनके घर वाले भी शामिल थे। एट दैट टाइम आल्सो दे डिड नॉट से दैट इंसिडेंट इज टेकिंग प्लेस ऑन दिस पंचनामा एग्जिबिट P3 is of dated 8/9/15 में पुलिस ने बनाया, इन्वेस्टिगेशन की। एट दैट टाइम आल्सो डिड नॉट से 8/9/15 एग्जिबिट P3 पंचनामा नक्शा पंचनामा। इसमें हम पंचांग के राय से मिलते कि इसमें हबीब अहमद जो PW2 है, फादर मदर उन लोगों के घर वालों के साइन भी रफीका। नक्शा पंचनामा 8/9/15 डेटेड। इसमें नीचे में हबीब अहमद के भी साइन है। तो पुलिस चौकी में जो इंफॉर्मेशन दी गई, इफ दैट विल आल्सो बी सीन बाय द डॉक्टर, उसमें लिखा था कि तुफैल खान, नीचे लाने वाले तुफैल खान हस्बैंड, मतलब ये पुलिस स्टेशन में इंफॉर्मेशन दी गई थी 2/9/15 को। मृत्यु की सूचना सेंड बाय द डॉक्टर एस के ईरानी, प्रति पुलिस अधीक्षक 2 मृत्यु की सूचना इरफान बानो तुफैल खान 26 वर्ष सतना, उक्त महिला को आग से जलना बताकर नागौद अस्पताल से रेफर होकर दिनांक 2/9/15 को 4:45 पर जिला अस्पताल सतना से मृत अवस्था में लाया गया। शव को शवगृह में रखा गया। आवश्यक कार्रवाई सूचना पेश घटना बताए अनुसार वार्ड नंबर 100 सिंहपुर, लाने वाला तुफैल खान मृतका का पति।
ये देखिए, इसमें कोर्ट की फाइंडिंग ये है कि आप उस दिन जले ही नहीं थे। आप जिस दिन लाए थे उस दिन आपको कोई इंजरी नहीं थी, बर्न इंजरी, ये आपने बाद में क्रिएट की है।
डॉक्टर्स से कि हम उस दिन जो है जले थे, बट आई वेंट टू द हॉस्पिटल नेक्स्ट डे बिकॉज आई वाज टेकिंग केयर ऑफ माय वाइफ, आई वाज नॉट टेकिंग केयर ऑफ माई सेल्फ। द नेक्स्ट डे जब जलन का थोड़ा सा ज्यादा हुआ तब फिर मैं जाके अपना इलाज के लिए फिर किए। आई वाज बर्न माय लॉर्ड, दैट इज आल्सो बीन सेड बाय द IO एंड डॉक्टर HK अग्रवाल PW6 ये कहते हैं कि मैं दिनांक 4/9/15 को जिला चिकित्सालय में मेडिकल अफसर पद पर था। उस दिनांक को आग से जले हुए पुरुष को, जिसका नाम तुफैल खा था, को जिला चिकित्सालय में उस दिनांक को समय में PM उपचार हेतु लाया।
के बाद की घटना
जो बात की अगले दिन आई वेंट 2 को इंसिडेंट, हमने 3 को जला हुआ।
कोई एविडेंस है कि 2 को जब आप ले गए थे तो आप भी जले हुए थे?
बिकॉज आई वाज कैरिंग हर, टेकिंग केयर एंड आई हैव टेकन हर टू द
गिवन ए फाइंडिंग की। अगर ऐसा होता तो आपने ये बात लिखाई होती कि हम उसको बचाने में जल गए थे।
And I informed the police also. This has also been said by PW8 SI जो है सत्येंद्र सिंह, पैराग्राफ 2।
आपने एग्जिबिट P18 में इसका जरूर जिक्र कराया होता
जी। PW8 जो है विटनेस सब इंस्पेक्टर पैरा 2 में यह कहना सही कि प्रदेश 1 की डॉक्टर द्वारा भेजी गई सूचना चौकी होने के नाते मुझे, जिसमें पुरुष को आग से जलकर बताकर लिखा है जो पुरुष जला था उसकी MLC कराई गई थी या नहीं मुझे नहीं मालूम। यह कहना सही है। चिकित्सालय ने जो सूचना मुझे प्राप्त हुई उस पर मैंने कोई कार्रवाई नहीं की थी। सेड बाय PW8 सत्येंद्र सिंह, रिटायर्ड सब इंस्पेक्टर मतलब। एंड इन माय documents and this PW Habib Khan in paragraph they say कि no previous complaint was there regarding torture। paragraph 16 में ना
ऐसी कौन सी है आपकी
जी सर,
ट्रीटमेंट हुआ, कोई MLC वगैरह ट्रीटमेंट पेपर?
जी डॉक्टर ने कहा है सर इसका एविडेंस में
नहीं, डॉक्यूमेंट कौन सा एग्जिबिट है?
ये सर PW6 जो डॉक्टर है, डॉक्टर HK अग्रवाल, ये कहते हैं कि लाया गया था ट्रीटमेंट।
एग्जामिनेशन किया तो कोई पेपर तैयार किया गया उन्होंने?
जी सर, ये एविडेंस में आया है। डॉक्टर PW6 डॉक्टर HK अग्रवाल।
पेपर कौन सा तैयार किया, MLC या कुछ भी?
जी MLC में ये सर इसमें लिखा मैं
पेपर कौन सा पे एग्जिबिट हुआ होगा ना?
हाँ सर, ये PW6 डॉक्टर HK अग्रवाल सर।
डॉक्टर ने एग्जामिनेशन किया तो कोई MLC
जी सर इसमें
तैयार किया गया?
जी सर
प्रिस्क्रिप्शन है क्या?
जी इसमें मैं दिनांक 4/9/15 को जिला चिकित्सालय से
प्रिस्क्रिप्शन कौन सा है, कौन सा प्रिस्क्रिप्शन?
रिकॉर्ड में, ओरिजिनल रिकॉर्ड में
है नहीं कोई
I'll
एग्जीक्यूट।
inspect the position.
डॉक्टर अगर इन्होंने एच के अग्रवाल ने एग्जामिन किया है
जी।
इसमें एग्जीक्यूट होता है ना पेपर, कोई एग्जीक्यूट नहीं है पेपर।
I'll point out from the report. I'll take
इसमें
time.
एक कहाँ जले ये तक मेंशन नहीं है, शरीर का कौन सा पार्ट जला आपको?
I'll inspect the original report, Malol, and I'll give maybe next week if possible.
After arguing for quite some time, praise for time to inspect the record. We are allowed list after 2 weeks. We'll assemble in 5 minutes.
Number 37.
Objection is overtaken. I pray for 10 days time for filing.
10 days time to
My
file.
lords, may I make a small request in this matter? My lords, there are three appellants in this case. My lords. Two have been convicted, sentenced for 7 years. One has been sentenced for 20 years. My lord, but by mistake, my lord, I have jointly filed the application for suspension for all three. So, my lord, I want to pray for those who are sentenced for 7 years. For those, my lord, the objection is not required.
You are pressing only for those who are in 7 years.
My lords.
Mr. Gupta,
Yes.
you are ready for that. Who are they? Appellant number
2 and 3.
2 and
3. My lord, they have been applicant number, my lord, 2 have been convicted under section 363 and 3. My lord, 2 and 3, yes, lord. Vivek and Sanjay Yadav. Applicant number 2 has been convicted under section 363 and 366A, and applicant number 3 has been convicted under section 368. My lordship, prosecution story is at, my lord's, page number at para number 3.
yes.
अभियोजन का पक्ष संक्षेप में इस प्रकार है कि दिनांक 1/3/2021 को अभियुक्त्री की मां या थाना चादरहाट
Reading
जिला
from paragraph.
para number 3 my lords, there are two para number 3 by mistake my lord, internal page number
Right.
4. अभियोजन का पक्ष संक्षेप में इस प्रकार है कि दिनांक 1/3/2021 को अभियुक्त्री की मां ने थाना चादरहाट जिला हैदराबाद में एक लिखित आवेदन आर्टिकल ए इस आशय का दिया था कि उसकी 16 वर्षीय पुत्री घर से कॉलेज का बोलकर गई थी जो वापस नहीं आई है, जिससे तलाश किया कि
62. IA number 6962 of 23 for suspension of sentence is taken up. Not at the outset, learned counsel for appellant praised for withdrawal of this IA for appellant number 1 with the liberty to file a separate application. But he pressed this IA for remaining appellants. And the application is arising out of public legal. Learned counsel for applicant by taking this court to the prosecution story submits that the prosecutrix had a love affair with main accused appellant number 1. She, along with appellant number 1, traveled to Bhopal and stayed at the house of appellant number 3. Appellant number 2 merely accompanied appellant number 1 and the victim from Bangalore, Hyderabad to Bhopal. The statement of victim and the prosecution story makes it clear that appellant number 3 was not informed by appellant number 1 or by the victim about their relations, and appellant number 3 was given to understand that victim wants to write an examination at Bhopal, and therefore under that bona fide impression, appellant number 3 provided her shelter. As per prosecution story, neither appellant number 2 nor appellant number 3 committed any sexual assault against to the victim. Considering the aforesaid factual backdrop and short sentence, remaining jail sentence may be suspended, but more so when final hearing of this appeal is not possible in near future. The government counsel opposed the same but did not dispute the aforesaid limited role of the appellant number 2 and 3. Considering the aforesaid and without expressing any conclusive opinion on the merits of the case, we deem it proper. इनको 30,000 की जमानत कर दीजिए ट्रायल कोर्ट भोपाल के सामने 28 अगस्त and further dates.
Bill number 38 along with connected case.
Lordship, our 10 days time for filing the return.
Lordship, in my case, they have
Item number
filed
38.
so I'm prepared to argue item number 38. They have filed the objection in that case.
Objection is not filed in connected matter.
Yes, Lordship.
Within how much time you will file it?
10 days.
It has been more than. Why 10 days?
4 days. 4 and 5 days.
We'll keep it on Monday. You file in between.
Yes.
We'll hear you. It will be convenient for the court also to deal with the role of both the appellant simultaneously. देखिए 38.1 में देना है जवाब.
Yes, Lordship.
38.1 में लिखेगा श्री अजय गुप्ता senior counsel with Shri Mishra for the appellant as prayed by government counsel. 7 days time as the last chance is granted to file response. List on Monday.
Let it be on 20th then.
Tuesday. List on Tuesday with connected matter.
I am appearing in 38, Lordship.
With connected matter we have said.
Bill number 39.
This case has been wrongly listed before DV, my lord. It should go before single bench.
Likeshe AP Singh at the outset submit that it's a single bench matter. The registry may verify and list before appropriate bench on Thursday.
Right.
On Thursday.
Bill number 40.
My lord, I want to withdraw my lord this appeal. Actually, my lord already filed my lord my lord appeal, and this appeal, second appeal has been filed my lord.
Likeshri
Yogesh Kumar Chaurasia, my lord.
Yogesh Chaurasia seeks to withdraw this appeal
My lord.
with the liberty to prosecute CRA number 45/23,
Already filed.
which is already filed by present appellant. The government counsel has no objection. CRA is dismissed as withdrawn with the liberty prayed for.
Alright.
Serial number 41 along with connected case.
This appeal is listed for the mentality. So victim appeal under 307, the conviction is 3 years. But I am on the ground of acquittal of 506 part 2 as well as inadequate compensation. So provision of 372 would be applicable. The registry has pointed out mentality of.
What is the objection of maintainability by
Well, it ought to have been revision because enhancement, but the order is
CRPC? The registry says that you should have filed CRA.
CR, it is CRA.
Revision.
Revision for enhancement.
397.
Yes.
You are placing reliance on which provision?
372 itself. Provision of 372.
What you are claiming? Enhancement.
I am saying it's not a claiming against the acquittal. Just have the provision, pursuant of provision 372.
Yes.
Provision. Provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compulsion. The word is convicting for a lesser offense, then the revision would be light. But for the second two parts, acquitting the accused and inadequate compulsion, the provision would be applicable. Now, in my case, 1,000 rupees has been compensated, three gunshot injuries has been made, and the bullet has been marred on the car. So 1,000 rupees has been given as a compensation, and there is an acquittal.
Seeking enhancement of compensation.
Compensation as well as there is acquittal of two sections.
Three Ankita Saxena for the appellant is such and such. Heard on office objection. In view of proviso to section 302 of CRPC, the office objection is overruled. Appeal is admitted for hearing. Record of court below requisitioned. Available इसमें
connected matter में उनको bail हो चुकी है already because 3 years की conviction थी 307.
List with connected matter.
That's it. I am only notice में only.
Issue notice कर दिए. Issue notice to the private respondents.
Online.
Serial number 42.
Password. Password.
Serial number 43.
Lordship, I am withdrawing criminal appeal number 3047 of 23 as the earlier will continue, Lordship.
देखिए श्री दिलीप परिहार for the appellant, Shri such and such for the state. Heard on office objection. At the outset, Shri Parihar seeks to withdraw this appeal with the liberty to pursue.
Criminal appeal number 12299 of
CRA
22.
उसमें आप appellant हैं?
No, sir.
है तो उसमें CRA 12299 of 22. Shri such and such has no objection. CRA is dismissed as withdrawn with the liberty prayed for.
No, sir.
Three point one का list admit हो गई है. List for final hearing in due course.
Serial number 44.
Password.
Serial number 45. Along with connected case.
Lordship, maintainability per.
No regrets, madam. Your mobile rang up in.
Lordship, sorry. Still
No
sorry,
regrets.
Lordship.
First of all, you should feel sorry about it. Yes, argue.
लॉर्डशिप मेंटेबिलिटी पर इसमें दो अपील फाइल हो गई है लॉर्डशिप. ये जो मुझे मिली है वो लीगल एड से मिली है लॉर्डशिप.
लीगल एड की पहले की है कि दूसरी वाली पहले की है?
लॉर्डशिप नंबर.
Which appeal is filed prior in time?
लॉर्डशिप जो लीगल एड से मिली है उसका नंबर है 5003/23
देखना दूसरी
45 नंबर.
डेट ऑफ फाइलिंग क्या है?
ये डेट ऑफ फाइलिंग लॉर्डशिप 6/4/2023 का.
इस वाले की देखिए. January. So the prior appeal will continue, madam. She is engaged. She is engaged an advocate.
लॉर्डशिप.
लिखे item number 45 में लिखेगा MS हेमलता क्षेत्रीय.
जी.
For the
क्षेत्रीय लॉर्डशिप.
For the appellant. Heard on office objection. Learned counsel for appellant submits that this appeal is filed by appellant by obtaining legal aid. But however, it is noticed that CRA number 1869 of 23 is filed prior in time by the same appellant against the same impugned judgment by engaging a counsel. But thus, appeal filed prior in time will prevail. Notice the CRA 5003 of 23 is dismissed by reserving liberty to the appellant to prosecute CRA 1869 of 23.
Okay.
45 भी admit नहीं हुई हो गई 45.1 को लिखिएगा list this admitted appeal in due course.
Serial number 46.
पास हो गया.
Serial number 47.
पास हो गया. 47 दे दीजिए लिखिएगा none for the appellant श्री such and such IA number 11733 of 23 is taken up seeking withdrawal of appeal by appellant number 1 भगवान दास एक ही की है ना एक ही लोग एक ही की आई है भगवान दास not in absence of opposition as like the said application is preferred by said appellant through Central Jail Sagar wide letter number 2918 /Vidhi /2023 dated 7/5/23. But IA is allowed. Appeal is dismissed as withdrawn for appellant number 1. Registry shall delete the name of appellant number 1 from array of parties. Forthwith, copy of this order be sent to appellant number 1 forthwith. Appeal shall continue for remaining appellant.
Serial number 48.
ये भी withdrawal है लिखे none for the appellant such and such IA number 11235 of 23 is taken up seeking withdrawal of appeal. Application is preferred through Central Jail Narsinghpur wide letter number 2865 /warrant 2 /23 dated 8th May 23. Government counsel has no objection. IA is allowed. Appeal is dismissed as withdrawn. The record of court below be sent back. A copy of this order be sent to the appellant by registry.
Serial number 49.
इसमें लिखिएगा सिर्फ सोल appellant है ना सिर्फ इतना चेंज हो जाएगा IA number will be 11238 of 23. लेटर नंबर हो जाएगा 2881 /warrant 2 2023 नरसिंहपुर 8th May 23 है ना बाकी सेम है.
Serial number 50.
आर्गुन काउंसिल आउट ऑफ स्टेशन लॉर्डशिप
तो विड्रॉल की एप्लीकेशन आई आपके पक्षकार की जेल से सीधे कितने एपेलेंट हैं इसमें 16 एपेलेंट है एक ही एपेलेंट डिसमिस विड्रॉल ये भी विड्रॉल है इसमें लिखिएगा ये नंबर दिस इज 51 ये नंबर 11735 of 23 is taken up seeking withdrawal of appeal on behalf of appellant शोभाराम क्या है
हमारा हम एप्लीकेंट नंबर 2 की ओर से
शोभाराम की तरफ से
नहीं एप्लीकेंट है मुन्ना
नहीं शोभाराम की आई है
जी
नंबर 1 appellant number 1 शोभाराम है ना थ्रू जेल This application is preferred through Central Jail Sagar wide letter number 3060 oblique Vidhi oblique 23 dated 9/5/23. In absence of opposition, IA is allowed. Appeal is dismissed as withdrawn for appellant number 1 Shobharam. Name of appellant number 1 be deleted from array of parties by registry forthwith. Copy of this order be sent to him forthwith. Appeal shall continue for remaining appellants.
Serial number 52.
इसमें हमारा ये मुन्ना एप्लीकेंट नंबर 2 की ओर से है। ये 51 में
51 में विड्रॉल है 1 की तरफ से। विड्रॉल की एप्लीकेशन आई है जेल से भगवान दास शोभाराम के लिए।
नहीं, हमारा सर मुन्ना है, इसी में भगवान दास में ही मुन्ना है एप्लीकेंट नंबर।
वो सस्पेंशन के लिए है।
जी हाँ, वही उसी में
रेडी हैं उसके।
हाँ, उसी के लिए
दीजिए उसको भी कंटिन्यू करेंगे।
ये फिफ्थ बेल एप्लीकेशन।
एनी प्रीवियस एप्लीकेशन डिसाइडेड ऑन मेरिट्स? मेरिट पे कोई नहीं हुई है। श्योर
एज पर माय नॉलेज सर।
नॉट नॉलेज, यू हैव टू मेक इट डेफिनेट स्टेटमेंट। Don't expect us to see 50 order sheets to where you have to make a responsible statement.
17/6/19 को सर फोर्थ डिसमिस हुई है।
17/6/19।
There are 4 accused persons in this case, Lordship.
We are concerned with Munna.
जी हाँ, I'm concerning with Munna.
Yes.
Allegation against
आपके पास पेपर बुक है? आपके पास पेपर बुक है?
नहीं सर।
एक्स्ट्रा है क्या पेपर बुक? आपको दिलवा देते हैं, इसको मंडे को कर लीजिए।
जी
है ना? कॉपी ऑफ पेपर बुक is provided to श्री आशीष तिवारी as prayed by him, list on Monday. वो जो पहले का ऑर्डर यथावत रहे।
Serial number 52.
लॉर्डशिप इसमें जेल रिपोर्ट बुलाई थी कि वो कब से जेल में? सीरियल नंबर 52
जेल रिपोर्ट, कस्टडी रिपोर्ट।
कस्टडी रिपोर्ट आ गई। उसमें आया है जो रिपोर्ट आई 10 साल 1 माह 17 दिन हुए जेल में।
नहीं आई कस्टडी रिपोर्ट?
आ गई 10 वर्ष 1 माह 17 दिन का आया।
ये आपने पर्सनल बॉन्ड पे छोड़ने के लिए कोई एप्लीकेशन? क्यों यू डोंट, बेल हो गई थी इसकी?
यस सर।
ही डजंट हैव मनी टू
पर्सनल बॉन्ड।
आपने कोर्ट ऑर्डर ये देखा है 12/5/23 का?
लॉर्डशिप उसमें 20,000 रुपीज का।
मिस्टर सिंह, आपके लिए कुछ डायरेक्शन था?
इसमें रिपोर्ट आई, उसमें आया कि वो जेल शेड्यूल जेल से रीवा जेल में स्थानांतरण हो गया।
आपसे ये पूछा था कि आप वेरीफाई करिए कि इन्होंने बेल बॉन्ड दे नहीं पाए इसलिए बने हुए हैं जेल में, या इन्होंने बेल जंप की है। कोर्ट ऑर्डर डेटेड 12/5/23।
टू डेज समय देते हैं। Verify
as spread by government council list on Monday as a last chance list on Monday.
Yes, ma'am.
To enable him to comply with the court order dated 12/5/23.
Serial number 53.
Means this is an appeal, victim's appeal, and we had moved an application under section 391 of the CRPC in this appeal minutes.
What?
Because the ground for acquittal was that there was a suicide note which was given to the police, and the court has held that we were not.
The reply has already been filed.
The reply of the accused persons has been filed. If the state so desires, then they
You may file your reply. We consider all this at the time of final hearing.
As it pleases, my lord.
Because Shri Vishal Daniel for the appellant, Shri such and such for the state, none for the accused. Accused person has already filed response to the application filed under section 391 of CRPC by the appellant. If state desires, it may also file its response within 4 weeks. The application under section 391 will be considered at the time of final hearing. List in due course.
I was obliged.
Serial number 54 along with connected case.
Kindly next week. Next week.
Why you are not ready today, madam?
Have searching some necessary rules.
Yes, please.
Necessary rules search करना है that ये work charge contingency paid employee pension rule 19
ready? आप क्यों ready नहीं है आज?
अभी rule नहीं मिल पाया है.
देखिए, as spread by MS Ninima Gupta as a last indulgence, list this matter on next Wednesday with connected matter.
Serial number 55.
In this petition, I want to withdraw this petition.
देखिए, श्री Anand Shukla seeks to withdraw this petition unconditionally.
That's very infectious हो गई.
Seeks to withdraw this petition because it has rendered infructuous. Shri Ankit Agrawal GA has no objection. Petition is dismissed, having dismissed as withdrawn.
Serial number 56 along with connected case.
Petition is still first time we are kindly record call.
Admitted for hearing, record of court below be requisitioned.
Always.
दोनों same.
Serial number 57.
कितना delay? There is no delay.
No.
Record बुला लीजिए.
Yes.
Serial number 58. PS Chauhan.
This is against conviction.
Against conviction.
Okay, none for the appellant is such and such. Admitted for hearing, record of court below be requisitioned. Record आ गया. सिर्फ admitted for hearing कर दीजिएगा. List in due course.
Serial number 59.
Record.
Against conviction.
Conviction.
Admitted for hearing, record आ गया. List in due course.
Serial number 60.
कितना delay है Mr. Shiva?
160 days delay, Lordship.
क्या reason बताया आपने?
But the release was received from the legal aid, Lordship, and applicant was inside the jail.
Shivare for the appellant is such and such. IA number
4997
of 23 for condonation of delay of 160 days. 160 days is taken up. Appellant has filed this appeal by obtaining legal aid. The said process consumed some time, but we are satisfied with the cause shown. Accordingly, IA is allowed, delay is condoned, appeal is admitted for hearing, record of court below be requisitioned.
Lordship, IA number 4999 also did the exemption of the from the
IA
affidavit.
4999 of 23 seeking exemption from filing affidavit is also allowed.
Serial number 61.
24 days delay, my lord.
देखिए, record of court below be requisitioned.
Serial number 62.
62 same record बुला लीजिए. 63 same record बुला लीजिए.
Serial number 64.
Against conviction? Is it against conviction?
Yes, sir.
None for the appellant, Shri Kashyap GA for the state. Admitted for hearing, record of court below be requisitioned. Record है, सिर्फ admitted, list in due course. 65 में record बुला लीजिए.
Serial number 66. Shri Jiten Tiwari.
लिखिए, none for the appellant, admit नहीं हुई है. Admitted for hearing, record of court, record आ गया. Reply देना है आपको. Suspension की application.
Yes, ma'am.
Reply to pending IA be filed within 2 weeks, list thereafter next.
Serial number 67.
इसमें भी मैं reply दे
67 में लिखे admitted, none for the such and such, admitted for hearing, record of court below be requisitioned. Reply of pending IA be filed within 15 days. List thereafter.
Bill number 68. Shri Vivek Kumar Gautam, Shri Vikram Singh.
What is this appellate appeal?
Well, this is rejection of his prayer for compassion.
We'll pass it over because we granted him last chance. Pass over. Will come very soon.
Well,
Serial number 69.
Well, my lord, I am appearing on behalf of respondent number 2, my lord. Void order dated 12/4/2023, my lord.
12/4/2023,
my lord.
12/4
For
you are furnished bail. You furnished bail.
I furnished bail before the CJM, my lord, for presence, my lord.
This is against acquittal.
My lord, my.
Record आ गया. You will admit it is already admitted, I believe.
My lord, the matter was fixed for appearance, my lord. Today he is not appeared, and I had filed an application for exemption for personal appearance, my lord.
You continue to appear before court below.
My lord, yes.
Do you have any order to show that you have furnished bail before court below?
That's the order sheet I had. I do not have, my lord. I had filed affidavit कि इसने furnish कर दिया.
अगर आपको बेल दी होगी नीचे कोर्ट ने तो कोई ऑर्डर पास किया होगा ना उसमें.
ऐसे ऑर्डर नहीं है my lord मेरे पास अभी.
आपके पास होना चाहिए ऑर्डर. देखिए श्री कपिल Duggal for the appellant Shri Vikas, as prayed by Shri Vikas Joshi, listened the next week to enable him to produce the document to show that he has furnished bail.
Serial number 70.
What is this?
Personal appearance, my lord.
Mr. Daniel, he was here few minutes back. पास ओवर करिए वो देखते हैं.
Passport cases. Serial number 7.
Item number 53, my lord.
We are at 7.
53, my lord. Reply has been given by me.
Let number come. We will go serially. 7. Item 7. Anybody? देखिए none for the appellant even in the passover round. Shri Arvind Singh for the state. IA number 7078 of 23 is dismissed for want of prosecution.
Serial number 16.
Same order. IA number will be 4427 of 23.
Serial number 29 along with connected case.
26 भी था. अच्छा.
Lordship, I am here for the appellant for Shivraj.
Any previous application decided on merits?
Lords and praying it may be taken after day after tomorrow.
Which one?
Lord 29. Lord. It has to be argued by Ms.
Who is appearing? Both out of both of you.
Sir, I am in 29.1, sir. In connected cases.
He is asking for day after tomorrow. Any objection?
No, sir.
29 and 29.1 में लिखिए as agreed. परसों लगा Wednesday.
Okay.
Serial number 42 along with connected case.
देखिए 42 में लिखिएगा मेंटेनेबिलिटी पर है. None for the appellant even in the passover round as a last indulgence list on Wednesday with connected matter.
Serial number 44.
एक मिनट 42 दीजिए. ये एक ही आदमी ने 2 अपील फाइल कर दी. दिखाइए देखना दोनों में कौन सी पहले फाइल हुई है. 42.1 पहले फाइल हुई ना. उसमें ऐसा लिखिएगा 42 में none for the appellant even in the passover round. Shri such and such for the state. The matter is listed with an objection regarding maintainability raised by registry of this court. But it is seen that present appellant has filed 2 appeals arising out of same impugned judgment. Dot since CRA number 567 of 22 is pending and filed prior in time, comma, the CRA 3043 of 23 is not maintainable. Accordingly, this CRA is dismissed by reserving liberty to the appellant to prosecute CRA 567 of 22. और जो 567 है 42.1 उसको लेकर लिस्ट इन ड्यू कोर्स.
Number 44.
क्या ऑब्जेक्शन है? Maintainability का ऑब्जेक्शन क्या है? वो क्यों नहीं लगाई साथ में? लिखे in none for the appellant even in the passover round. List this matter in view of office objection. List this matter with CRA number 4300 of 23 on Thursday. परसों लगा Thursday को लगा.
Number 46.
देखना क्या मेंटेनेबिलिटी का ऑब्जेक्शन. इसमें लिखे none for the appellant as a last even in the passover round as a last indulgence list on Monday.
Number 68. Gautam, Vikram Singh.
None for the parties even in the passover round. The writ appeal is dismissed for want of prosecution.
Number 70.
लिखिए दिखाइए क्या कर रहा है. अपीयरेंस दीजिए. क्या रिपोर्ट है क्या बेल पर शामिल हुआ है क्या वारंट रिपोर्ट फर्निश कर दिया. लिकेश इन्होंने फर्निश कर दी है. लिकेश श्री such and such for the appellant, none for the respondent. The as per report of learned JMFC Sivni dated 24/4/23, the respondent has furnished bail and was directed to remain present before registry of this court today. But none appeared for respondent today. In order, the respondent shall mark his presence before the court below. नीचे कर देते हैं बता किसी क्यों आया वहां से आदिवासी महिला है ना. Before the learned JMFC Sivni on 28th of August 23 and further dates decided by the said court. Dot registry shall provide copy of this order to Shri Vishal Daniel forthwith.
Serial number 26.
Interesting question है कि इसको आखिरी में रखा था. You have to tell everything afresh because the constitution of the bench is now different.
Lord, may kindly have me, Lord, the compilation that I had submitted on the earlier.
You have compilation of judgments.
My Lord, there were compilation of judgment as well, my Lord, the decision of the juvenile board as well as the appellate order, my Lord, there must be two compilations.
This is that compilation.
Well,
Yes. You just tell us the basic facts so that.
My Lord, the allegation against my Lord, the appellant is that, my Lord, he has. My Lord, the allegation against the appellant is that, my Lord, he has conducted, my Lord, the sexual assault or rape against the victim. My Lord, the issue here is that, my Lord, he was admittedly, my Lord, the appellant was of age 16 years and 5 months.
16 years?
And 5 months. My Lord, there is a provision in the Juvenile Justice Act under section 15. If, my Lord, a person who is, my Lord, above 16 years of age, if he is found to be, my Lord, if he is alleged to be, or there is allegation of a heinous crime, he may be tried as an adult. Now, my Lords, in section 15(1), if my Lord will read, my Lords may allow me to read section 15 subclause 1.
Yes.
In case of a heinous offense alleged to have been committed by a child who has completed or is above the age of 16 years, the board shall conduct a preliminary assessment with regard to his mental.
You're talking about the 2015 Act.
15 Act.
Just a minute. Yes. Can you read it again?
In the case of a heinous offense alleged to have been committed by a child who has completed or is above the 16 years, the board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit such offense, ability to understand the consequences of the offense, and the circumstances in which he allegedly committed the offense, and may pass an order in accordance with the provision of subsection 3 of section 18. Provided that such an assessment, the board may take the assistance of experienced psychologists or psychosocial workers. Now, my Lord, this proviso, the Supreme Court in, my Lord, in the recent judgment which I have filed in the compilation, has said that, my Lord, this should be read shall, and it is the mandatory for the board to conduct the psychological assessment. Now, my Lord, that judgment is at, my Lord, page number 45 of the compilation. Lord, it is on page number 8 of the compilation. And
page number 8?
8. It starts from page number 8. Lord, the relevant paras are 74 to 80.
Page number 8 is a judgment in Hindi. Sorry. This is a judgment by Justice Maheshwari, bench of Justice Maheshwari, Dinesh Maheshwari. Paragraph is which
74 to 80. Lord, I'll read the relevant paras. Lord, para number 74.
Yes.
The world acknowledges that the children in conflict with law should be treated differently than adults in the conflict of law. The reason is that the mind of the child has not attained maturity and it is still developing. Therefore, the child should be tested on different parameters and should be given an opportunity of being brought into the mainstream if during his juvenility he has acted in the conflict of law. To understand the psychology of the child, huge rounds of the studies have been made not only recently but from age-old times, and child psychology is a subject which is being studied world over, and there are institutes specifically dealing with the development and research on the said subject. The enactments and dealing with the children are enacted world over. It is to be noted that child psychology is a specialized branch of development psychology. Its genesis is based on the premise that children and adults have different thought process. The individualized assessment of adolescent mental capacity and ability to understand the consequences of the offense is one of the most crucial determinants of the preliminary assessment mandated by Section 15 of the Act 2015. The report of the preliminary assessment decides that the germane question of transferring the case of child between 16 to 18 years of age to the children's court. This evaluation of mental capacity and ability to understand the consequences of the child in conflict of law can in no way be relegated at a status of a perfunctory and routine task. The process of taking a decision on which the fate of child in conflict of law precariously rests should not be taken without conducting a meticulous psychological evaluation. as already mentioned, the board consists of 3 members. One is a judicial officer first class, 2 are social workers, one being a woman. The social worker appointed a member could be having a degree in child psychology or psychiatry, but it is not necessary. As such, the constitution of the board may not necessarily be having an expert psychologist. It is for all the above reason that it has been provided not only in section 15 and 101 subclause 2, but also under the model rules that assistance may be taken from expert psychologists. Having regard to the framework of the Act of 2015 and the model rules, the purpose of preliminary assessment in terms of section 15 is also looking to the varied composition of the board. We are of the view that where the board is not comprising of a practicing professional with a degree in psychology or a child psychiatry, the expression may in proviso of section 15(1) would operate in mandatory form, and the board would be obliged to take assistance of the experienced psychologist and psychosocial worker. However, in case the board comprises of at least one such member who has been practicing professional with a degree in child psychology or child psychiatry, the board may take the assistance and may be considered proper by it. And in case of board chooses not to take assistance, it would be required by the board to state specific reason thereof. So, my lords, in this decision, my lord, in this judgment, the Supreme Court has held that it is mandatory for the children's court.
What is the relief granted in this case? This exercise was not undertaken.
No, my lords.
What was the relief granted by Supreme Court?
My lords, in this case, my lords, the expert, the preliminary report under section 15(1) itself was challenged, and therefore, my lord, it was the report was quashed and it was remanded back. But my lord, situation here is different because here, my lord, the trial is concluded. Now, my lord, the person, the appellant, my lord, he is above 20 years of age. Now, my lord, the matter cannot be remanded back. Now, my lords, there is one more, my lord, important judgment which is at page number 109 of the compilation. My lords, because the my lords had raised this question whether, my lord, this particular point can be raised in the appellate stage or not. My lord, there is a section 365 of the CRPC, which, my lord, may see as para number 36 of this judgment.
Section 360?
465, your lordship.
465?
465.
It talks about?
My lords, it talks about if there was a failure of justice because of an irregularity conducted during the trial or before trial, then, my lord, the appellate court has the power to reverse the judgment. My lords, in para number 36, my lord, that particular, my lord, the section has been reproduced. My lords, may I read the section? Yes, section 465. Finding or sentence were reversible by reason of error, omission, or irregularity. Subject to the provision herein before contained, no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, or revision on account of any error, omission, irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceeding before or during the trial, or in or any inquiry or other proceeding under this code, or any error or irregularity in any section for the prosecution, unless in opinion of court a failure of justice has in fact been occasioned thereby.
The core issue is whether it amounts to
failure of justice or not. My lord, my submission is that because whole case rests upon this fact whether, my lord, he was psychologically, my lord, competent to commit such an act, and without conducting the psychological assessment, my lord, he could not have been tried as an adult, and if it has been done, my lord, it is a complete failure of justice. And, my lord, similarly, in one of the cases, my lord, Rajasthan High Court, my lord, said convicted a person, my lord, he was a child, a minor who had, my lord, committed murder of his husband. My lord, the Rajasthan High Court acquitted the appellant therein, and as well as, my lord, awarded the compensation as well, because, my lord, it was held that he was
Justice Sandeep Mehta's judgment.
My lord, it is at page number 45.
By Honorable Bench of Honorable Justice Sandeep Mehta.
Yes, your lordship. Honorable Justice Sanjeev Mehta and Honorable Justice Vineet Kumar Mathur.
Yes.
In this case, your lordship may see at page number 1, because, my lord, there is no para numbered in this judgment. Page number 1, my lord, the brief facts. Being agreed by her conviction and sentences, the appellant has preferred an instant appeal under section 374 of the CRPC. Facts in brief. are that the complainant Onkar lodged a written report at police station Shankpura on 16/5/2016 alleging inter alia that on previous evening on 15/5/2016 his son Bherulal and his daughter-in-law Durga quarreled with each other because Durga had not prepared food. They were in a habit of fighting each other on small issues. The informant took dinner and after pacifying the spouse, he went towards the Nala to easing himself. Thereafter, he went to meet Hira. He returned from home at 11 o'clock, thinking that the spouse would have been gone to sleep in their room. He put a cot outside the house and went to sleep. In the night about 12 o'clock, he again heard the husband and wife quarreling with each other, upon which he woke up and saw Durga having an axe in her hand, which she had assaulted his son Bherulal on his neck. Bherulal was lying. Lord, these are the brief facts. Thereafter, may see, Lord, page number 2. Since the child arranged for a heinous offense as defined in section 2 of the Juvenile Justice Board decided to hold an inquiry under section 15 of Juvenile Justice Care and Protection Act 2015 to consider whether the child should be tried as an adult. After the statement of 2 witnesses has been recorded in purported inquiry under section 15 of the Act of 2015, the learned principal magistrate Juvenile Justice Board proceeded to pass an order dated 22/8/2016 observing that the child in conflict of law appeared to possess the mental and physical capability to commit the heinous offense, that she was in a position to understand the consequences of it, and accordingly directed the child should be subjected to medical examination to psychiatrist. Child was sent, Milord, this was done after Milord, she was tried as an adult and she was Milord referred to a psychiatrist for mental treatment without Milord having a psychological assessment done. Thereafter, your lordship may see at page number Milord 6, internal page number 6. As apparent for section from sub rule 2 of section 10A model rules 2016, the assistance of psychologists or psychosocial workers or other expert which board requires for carrying out the preliminary assessment should have experience of working with children in difficult circumstances. However, neither the assistance of any such psychologist was sought, or nor any psychologist or child psychologist having special experience of working with children in difficult circumstances was associated in the proceeding. Furthermore, we do not approve the procedure adopted by the Juvenile Justice Board while making the preliminary assessment, inasmuch the principle of natural justice were not adhered, and without any justification, without providing legal assistance, the child was sent and admitted in psychiatry department of MBH Hospital, Udaipur, on the basis of some random secret report, copy of whereof was not provided to her. Be that as it may, the Rule 10A4 provides that where the board, after preliminary assessment under section 15 of the Act passes an order, there is a need for trial of the child as an adult, it shall assign reason for the same, and copy of order shall be provided. However, plain and simple reading of the order 5/2016 indicates that the board did not provide the copy thereof. Thereafter, your lordship, the operative part, it is internal page number 14. 1-4. Lord, point number 3. The principal magistrate failed to adhere to the mandatory requirement of section 15 of the Act while holding the inquiry and making the assessment. Then point number 5, that preliminary assessment order is also vitiated for the reason for the appellant was unjustly kept and confined in the psychiatry ward of the hospital because no psychologist or psychosocial worker having experience of working with the children in difficult circumstances as mandated by section 15(3) of the Juvenile Justice Act was associated during the inquiry, and my lord, thereafter my lord, thereafter, my lord, at internal page number 15, in argument, my lord, then the court proceeds to deal it with it in the merits, and considering the facts and circumstances of the case at hand, even if it is assumed for a moment that the Juvenile Justice Board was justified in treating the appellant fit to be tried as an adult under section 15 of the Juvenile Justice Act, then too she could at best be guilty of section offense under section 304, being 21 years of age. She would entitled for the benefit of probation, thus looking into custodial period of approximately 3 years suffered for the appellant, there is no justification to remand the matter to trial court. And paragraph for a fresh trial is strictly adhering as per the provision of the Juvenile Justice Act. We therefore accept the appeal, set aside the impugned judgment 12/2018 passed by the learned session judge in Pratapgarh in session case number so and so, and acquit the appellant of the charge under section 302. The sentences awarded by the appellant by the learned judges has already been suspended. Thereafter, my lord, on the last page of this judgment, internal page number 24, the court proceeded to give compensation to the appellant as well. My lord may see. For the above observation of the Honorable Bombay High Court to be more relevant and germane, we hereby direct that for the blatant violation of the fundamental rights of the accused, appellant perpetrated by the circumstances noticed here and above, the state of Rajasthan shall make a payment of compensation in tune of 2 lakh rupees to the appellant there. Thereafter, my lords, I have 1 or 2 judgment more to my lords to refer. My lords may see at page number 70. My lord, this is a judgment where aims and object of the Juvenile Justice Act have been, my lord,
yes,
my lord, have been observed. What may come to para number 79.
Para 79.
My lords, before that, I'm sorry, Lord. So before that, my lord, may come to para number 64.
Beneficial legislation.
Benefit. It is a beneficial piece of legislation. And court in brief has said that the adults and children have to be treated differently and law treats them differently. Therefore, my lords, if there is...
In precise, it is para number?
My lords, para number 79. Even at the final stage, which after he is found guilty of the commission of an offense, he must be dealt with different vis-a-vis the adult prisoners only because his age is to be determined in the case of a dispute by the competent court or board in terms of section 26 of this act. Same would not mean the relevant date, therefore would be of one which he produced before the board. If such an argument is accepted, the same would result in absurdly in the given case, it would be open to the police authority to not produce him before the board before he ceases to be juvenile. If he is produced after he ceases to be juvenile, it may not be necessary for the board to send him in the protective custody and or release him on the bail, as result whereof he would be sent to judicial or police custody, which would defeat the very purpose of the act, and act had been enacted. The law cannot be applied in an uncertain position. Furthermore, the right to have fair trial strictly in terms of the act, which would include the procedural safeguard in the fundamental right of the juvenile. A proceeding against the juvenile must be conform to the provision of the act. Thereafter, my lord, in para number 80, in Dilip Saha versus State of Bengal, full bench of the Calcutta High Court in arriving the conclusion that the date of reckoning shall be one on which the offense has been committed. Thereafter, my lord, 81, the statute, it is well known, must be constructed in a manner so as to make an effective and operative principle of ut res magis velit quam perit. The court leans strongly against the construction which tend to reduce a statute to a futility, when two meaning, one making the statute absolutely vague, wholly intractable, and absolutely meaningless, and the other leading to certainty, a meaningful interpretation are given. In such an event, a letter should be followed. In para number 82, the submission of the learned Solicitor General that in this court the Umesh Chandra has wrongly been applied the test of imputing mens rea and holding that the children's was enacted to provide young children for consequences of the criminal act on the footing, and their mind at the age cannot be said to be a mature in the case of adult may have some substance, but said statement of law must be read and understood in context of section rule 4.1 of the rule so as the would understood in the proper perspective. Lord, this thereafter, my lord, there is one more judgment. I would not go into detail, which, my lord, there a contain of judgment which says, my lord, the Supreme Court, even at the after the final hearing has been disposed of, the claim of juvenility can be raised. Now, my lord, my submission is this is essentially a claim of juvenility.
There is no question of examining question of juvenility.
My lord,
you are not disputing your age.
Lord, I am not disputing.
You are saying that since you are above 16, as per section 15(1), what was required to be examined is whether you are capable to understand the gravity and all these things. You are not on that question of.
Lord, I am not on that question, but I am saying, my lord, it is essentially, it is similar to the claim of juvenility. Because, my lord, this is a question which goes root of the matter, and if the psychological assessment had been done and it was in my favor, I would have been acquitted, I would have been let go, because this was done, my lord, similar. There was two accused in this case. One was, my lord, below 16 years. He was around 15 years and 11 or 10 months. Because he was let go of, he was not given even a single day custody. He was abdomination. Even after reprimandation and warning, he was let go of.
Nature of offense is same.
He was, in fact, the principal accused. And, my lord, if I go to the merits of the case, my lord may see, my lord, he was the principal accused and I was framed later. And, my lord, it is, my lord, in the statements given by the prosecutor himself in the Juvenile Justice Board, she has categorically accepted that she had a quarrel with the co-accused, and thereafter, my lord, I intervened and I said some things in favor of my friend, which was co-accused. Therefore, my lord, on the suggestion of her mother, they framed me as well. My lord, it is there in the statement.
At present, you are only seeking suspension of sentence.
My lord, I am seeking suspension, but I'm also praying, my lord, that this may be heard and decided finally if possible.
Mr. Dhande, what is your response? You want to argue on finally? Are you ready for final hearing?
Final hearing, your lordship, is 2021 appeal, your lordship, and it may be heard in the final hearing. But if I am giving your lordship response to that his arguments, your lordship.
No, but you want that we should confine to suspension of sentence.
Yes, ma'am.
Are you ready for that?
My lord, I'm ready.
That
My
if we
lord,
confine ourselves only to suspension of sentence.
My lord.
Right. That's all, Mr.
My lord, I may also be allowed to submit on merits, my lord, merits of the case.
No, but today we are only considering the prayer for suspension. Yes.
My lord, may keep it in the final hearing in coming months, my lords, if that possible.
Because in the light of section 374(4), we can hear it at an early date.
Yes.
376 has, mein. Conviction is also under section.
Yes, 376.
We can hear it within 6 months.
Yes.
We are obliged to hear it within 6 months as per these
provisions of
legislative mandate.
Yes.
If both of you agree, we'll hear it on this Wednesday only finally.
My lord, may hear it on suspension, my lord.
तो एक दिन के लिए क्या करेंगे suspension? If you are ready to hear finally day after tomorrow.
My lords.
You should have said it on the threshold that I want to argue it finally. Because if I correctly remember, before vacation, your stand was that hear us only on the question of suspension. Is it correct or not?
My lord,
now,
this question was asked to me by your lordship and I said.
You argue it finally then. Okay. Shri, day after tomorrow. Shri Abhishek Singh for.
My lord, Aditya.
I'm so sorry. Shri Aditya Singh for the appellant is such and such in the teeth of section 374 bracket में 4 of CRPC. Learned counsel for appellant prays for listing of this matter for final hearing on Wednesday. He submits that points involved in this matter are squarely covered by various judgments. Shri Dande has no objection for early hearing. Has agreed list this matter for final hearing on Wednesday. Isi Wednesday. Wednesday or Thursday?
Thursday. It's any date.
Thursday.
Prepare a synopsis, small synopsis.
My lord, I am sorry for interrupted lordship. Item number 46 lordship.
What happened in 46?
My lord, इसमें आइए हमने फाइल किया लॉर्डशिप कन्वर्जन की लॉर्डशिप पहुंच नहीं पाया था। माय लॉर्ड आई एम सॉरी, दूसरी कोर्ट में था।
क्या भी हुआ क्या 46? आप आए नहीं दोनों राउंड में 19 के लिए रखा है, कोई एडवर्स ऑर्डर नहीं किया आपने मंडे के लिए। क्या मेंटेनेबिलिटी का क्वेश्चन?
यस माय लॉर्ड, मेंटेनेबिलिटी पे है।
आप क्या चाहते हैं?
माय लॉर्ड, मैं चाहता हूं इसमें 372 आएगा लॉर्डशिप। इसमें जो लेजर ऑफेंस थे लॉर्डशिप, इसमें इक्विटल
एप्लीकेशन फाइल करिए प्रॉपर।
फाइल है लॉर्डशिप,
कन्वर्शन की।
यस माय लॉर्ड, कन्वर्जन की एप्लीकेशन ऑलरेडी फाइल
कब फाइल की है?
ये लॉर्डशिप फाइल है 14/2/2023, 14 फरवरी 2023 को फाइल।
ठीक है, 19 को बताइएगा। फाइनल हियरिंग कॉल करिए।
फाइनल हियरिंग नंबर 1
डेथ सेंटेंस है कोई? कौन है काउंसिल?
नंबर 1 to 8।
मिस्टर अजय गुप्ता को बुलवाइए 2:15 है ना, उनको बुलवाइए 2:15
tender my apologies, minutes. There's an item number 70 on the motion hearing list of my lords' board. It's due to some technical error, my lords. I could not see it in the cause list. It's for personal appearance, my lords, of the accused in a state appeal. Probably my name was in the special leave in the MCRC. After it got converted, there must have been some technical error. The party is before my lords. If
Whether he has furnished bail.
minutes, he will.
We have already he has already furnished bail. We have only given him a next date so that he can appear before court below.
My lords, if my presence could be marked and if so required, his signature could be taken on the order sheet.
We have directed the registry to supply a copy of order sheet to you.
My lords.
Because we have directed him to mark his presence before court below.
Trial court minutes.
Before trial.
Ever so obliged.
You will get the order sheet.
Ever so obliged.
Yes, Mr. Gupta.
No, item number 1.
We are not finding readiness on your Facebook.
I couldn't get my file. I have read the file though. We can start it tomorrow.
So what we will do tomorrow, today? Nobody is ready.
I have read the file. This file I have read. Vijay Panchayat's matter.
Already tomorrow, but definitely tomorrow.
Surely.
Who is government ready? Tomorrow. How many matters?
I am told, my lord, all the initial matters are mine. I will take up one at
Which
least.
one you will argue tomorrow?
First, number 1. Number 1.
One with
Vijay Panchayat.
One with इसमें जो appellant के counsel है उनको भी inform करिए कल से सुनवाई होगी इसमें है ना death sentence.
Very good.
Yes, tomorrow.
Great.
Is any matter, Mr. Patel? Hearing party number 54.
Sir.
मैं बात कर लेता हूँ किसी को अलॉट किया हूँ मैं बुला लेता हूँ जब तक चालू करेंगे किसी को अलॉट
इनका शुरू करवाएं
जी
54.
I permit to make a call, my lord.
Please call him. It is assigned to whom?
I don't know.
Please call him. Register दीजिए आप जाइए. Three appellants.
Sir, इसमें there are 4 persons, sir.
The one name of one person is deleted.
जी, मृत उसकी डेथ हो गई थी सर.
So it is abated.
जी. और अशोक है राम कुमार राकेश 3. सर मैं so deceased is Swami. Date of incident 18/7/2010. The date 18/7/10 PM. Allegation against the appellant that he assaulted.
Just read para 3. It will.
Sir. Sir, account paper book में सर ये है.
Tell us the factual backdrop.
जी. Para page 72 sir.
Yes.
Yes. Para 3 sir मैं ID सर page 73.
Yes.
अब जो मामला संक्षेप इस प्रकार है, घटना दिनांक 18/7/10 को फरियादी झांसी में साइकिल से अपने घर ग्राम छोटा पोहा आ रहा था. जैसे ही बाबूलाल ढीमर घर के सामने से निकला तो अभियुक्त अशोक ढीमर व बाबूलाल ढीमर ने उसे पकड़ लिया.
Shri R.S. Patel for the appellants, Shri Arvind Singh for the state, GA for the state. With the consent finally heard, judgment dictated separately. Judgment में लिखेगा, this criminal appeal filed under section such and such takes exception to the judgment dated 30/8/12 passed in sessions case number 255/10 passed by learned 4th additional session judge Tikamgarh, whereby appellants were held guilty for committing certain offenses and directed to undergo sentences which are mentioned in a chart as under, है ना, वो चार्ट बना लीजिएगा, उसमें लिखिएगा in short the case of the prosecution is that डिजीज का नाम क्या है? स्वामी प्रसाद
धीमर या टीचर क्या लिखा है?
स्वामी प्रसाद जी, स्वामी प्रसाद धीमर लिख दिया, स्वामी प्रसाद धीमर होगा, स्वामी प्रसाद. In nutshell, in short, the case of the prosecution is that on 18/7/2010, the complainant Swami Prasad Dhimar, bracket में कर देंगे deceased, bracket close, was traveling on his bicycle from his village Chota Poha. क्या लिखा? Traveling to his village Chota Poha. Soon he reached the house of Babulal Dhimar, Ashok Dhimar and Babulal Dhimar got hold of him and forcibly had taken him inside their house, closed the door, and thereafter all the appellants / accused persons started assaulting him by means of lathi, luhangi, etc. The appellant, the complainant shouted for help, and upon hearing his cry, Kailash Rakwar, bracket में PW1, and Ram Singh Rakwar, PW2, reached to the place of incident. PW1 and PW2 asked Babulal, knocked the door of Babulal and asked him to open the door. The family members of Babulal, bracket में since deceased, bracket close, did not open the door, and they started abusing PW1 and PW2 from inside, and also started throwing stones, bricks from inside. Next May, the aforesaid prosecution witnesses, left with no option, informed the police, and in turn, police reached the scene of crime. At police ' instance, the doors of the said house were opened, and both the witnesses found that that complainant Swami Prasad was lying on the courtyard of the house of Babulal Dhimar. Next May, indisputably, comma, in the instant case, the FIR was lodged on 18/7/2010, exhibit
25.
Exhibit 25, P25, by the victim Swami Prasad himself at 20:30 o'clock. He died on the same day. Next में the police, after conducting the investigation, filed the charge sheet. In turn, the matter traveled before the Sessions Court. All the appellants abjured the guilt and pleaded innocence. Next में आप जाने the court below framed 6 questions for its determination and recorded statement of 13 prosecution witnesses and 5 defense witnesses. After recording the evidence, by impugned judgment, the court below held the appellants as guilty for committing offenses and directed them to undergo the sentence as mentioned in para dash above. Next में श्री side heading लिखेगा contention of appellant. Shri R.S. Patel, learned counsel for the appellants submits that during the pendency of this appeal, Babulal Dhimer, bracket में appellant number 1, died. The appellant number 2, 3, and 4 are family members of Babulal. It is submitted that the FIR was lodged by Swami Prasad on 18/7/2010. The FIR was recorded by इस नाम नहीं मालूम है उसका, नाम नहीं दिया
ये फरन सिंह ASI, फरन सिंह ASI
किस पेज पर आया?
ये सर 35 पे आया
35
जी, पैरा 8.
The FIR was recorded by ASI Feran Singh Rajput. Feran Singh Rajput. Since Feran Singh Rajput died during the pendency of trial, he could not enter the witness box on behalf of the prosecution. Learned counsel for appellant submits that in absence of his deposition, the appellant could not cross-examine him regarding the witness of Swami Prasad to lodge the FIR. In addition, it is argued that when MLC was recorded by PW, किसने रिकॉर्ड किया MLC?
सही है PW13.
PW13 नाम बताइए डॉक्टर.
PW12 पेज 31, डॉक्टर विनोद भारद्वाज.
PW12 डॉक्टर विनोद वाजपेयी, ब्रैकेट में PW12, he clearly admitted in para 18 that at the time of preparation of MLC, Swami was not in a fully conscious stage. Only his eyes were moving, but he was not totally conscious. Considering the aforesaid, it is submitted that there is no material to show that when FIR was lodged, Swami Prasad was in a fit state of mind to lodge the FIR. But for this reason, the appellants deserve acquittal because there is no material on the strength of which FIR can be treated to be a dying declaration. Next में Shri R.S. Patel fairly submits that he is confining his argument.
सर इसमें एक अशोक की सर उसको जो हुआ है कि 22/7 को बेल हो गई।
Only after asking you that you have nothing more to say, we
नहीं उसके लिए नहीं बोल रहा हूँ सर, मैंने स्टेटमेंट दे दिया कि सब लोग जेल में इतने साल हो गए, वो उसके कंट्राडिक्ट करता हूँ।
हम नहीं लिख रहे हैं उसको
सर,
आपने इसके अलावा और कोई बहस की नहीं है।
नहीं सर, मैं मतलब मेरी गलती है, एक व्यक्ति
Shri R.S. Patel confined his argument to the extent indicated above. Next में Shri Arvind Singh supported the impugned judgment by submitting that court below has considered the evidence on the basis of permissible parameters. There are eyewitnesses to the incident whose statement will show that they have stated about the oral dying declaration given by Swami Prasad to them. In view of the incident, the court below has rightly convicted and sentenced the appellants. Next, we have no other point is pressed by learned counsel for the parties. We have heard the parties at length and perused the record. Next, Swami Prasad was assaulted. As like the dead body of Swami Prasad, the body of Swami Prasad, the injured Swami Prasad was found inside the house of the appellants. On 18/7/2010, the date of incident itself, Swami Prasad lodged the FIR in the police station. The two important eyewitnesses entered the witness box in support of the prosecution story. Firstly, Kailash Rakwar (PW1) categorically deposed that when he heard the cry of Swami Prasad for help, he immediately rushed to the place of incident and found the door of house of Babulal locked from inside, and Swami Prasad was crying for help from inside the said house. He knocked the door and made several requests to the appellants to open the door, but the door was not opened. In turn, he called police, and only police could open the door of the house of Babulal. Inside the house, in the courtyard of appellant's house, the Swami Prasad was lying in an injured condition. Next, this witness Kailash Rakwar (PW1) categorically deposed that upon asking his grandfather, upon asking Swami Prasad informed him that Babulal, Ashok, Rakesh, Chotu and Ramkumar has assaulted him by means of lathi and luhangi. कैलाश के बारे में उसको छोड़ दिया होगा कोई अशोक पुलिस से किया है मौका तो एक सपोर्ट किया 3 and 5 भी सिर्फ अशोक के लिए हॉस्टाइल है जी बाकी नंबर 4 सभी के लिए 5 सबके लिए डॉट दी नेक्स्ट में लिखिएगा PW2 Ram Singh deposed his statement in the same line in which statement of Kailash Rakwar bracket में PW1 was recorded. This statement, his statement also shows that there exists an oral dying declaration wherein Swami Prasad informed him about the nature of incident, the weapon used, and the assault made by aforesaid accused persons. Thus, the oral dying declaration, thus the oral statement, ये काट दीजिए this oral statement. Next में लिखा the statement of these two eyewitnesses were further supported by statement of Beni Bhai bracket में PW4 and
PW5 भी है सर.
Sevak Rakwar PW5. It is pertinent to mention that Beni Bhai PW4 took a different view only in relation to the overt act of appellant number 2 Ashok Rakwar. है ना? नहीं 3 का तो भी लिखा ही नहीं, 4 and 5 का लिखा. 4 आपने 3 and 5 बोला था, वो जहाँ पे 4 and 5 आया ना, वहाँ पे 3 and 5 कर लीजिए. उसका 3 का नाम लिख लीजिएगा राजकुमार, है ना? PW3 का नाम है राजकुमार. नेक्स्ट में राजकुमार ब्रैकेट में PW3 has taken a different view about overt act of appellant number 2 Ashok Rakwar. Otherwise, rest of his statement about the overt act of other appellants is in tune with the statement of appellant number 5 Sevak Rakwar. A cumulative reading of state eyewitnesses, namely PW1, PW2, PW3 and PW5 और भी है, makes it clear that all of them have mentioned about the role of appellants with utmost clarity. Beni Bhai bracket में PW4 also deposed that Swami was assaulted by appellants by means of axe and lathi. The appellants did not open the door of their house, and instead throwing stones on this witness. The door could be opened only when police made efforts, and at that point of time he found the body of his uncle, his grandfather, at the courtyard of their house. Next में लिखिएगा the deposition of the statement of the statement of DP Praful Srivastav, sub inspector bracket में PW13, contains a note appended by the court wherein it is mentioned that ASI Fairan Singh Rajput, who recorded the FIR, is no more. In para 8 of this statement, the witness clearly deposed that the FIR was indeed lodged by ASI Peran Singh. This police officer produced the FIR from official custody and identified the signature of his fellow employee ASI Peran Singh. No amount of cross-examination could demolish his case, and therefore we find no reason to disbelieve the genuineness of the FIR. We are unable to persuade ourselves with the line of argument of Shri R.S. Patel that FIR cannot be believed because the person who has recorded it was not produced in the court. Non-production of said witness because of his death has not caused any prejudice to the appellant. More so when averments of the FIR find support with by two eyewitnesses, namely Kailash Rakwar bracket में PW1 and Ram Singh Rakwar PW2. Next में at the cost of repetition, it is noteworthy that PW1 and PW2 in clear terms deposed about oral dying declaration given by Swami Prasad to them, which shows culpability and the role played by the present appellants. The said oral statement relating to oral dying declaration could not be demolished during cross-examination. Next. In view of foregoing analysis, in our opinion, the FIR must be treated as a dying declaration. The FIR clearly shows that because of previous enmity, Swami Prasad was assaulted by the accused persons. Previous enmity relating to land. Previous enmity जहाँ पर आया, the appellant was Swami Prasad was assaulted. Thus, there existed a motive for assaulting Swami Prasad. The incident is an outcome of a premeditation. It is not outcome of any sudden quarrel. Indeed, the appellants with clear understanding and planning forcibly taken Swami Prasad inside their house, locked the house from inside and assaulted him on various parts of his body. The injuries found on the person of deceased as per autopsy report is as under, है ना, इसके पेज नंबर 77 में जहां पर है, यहां से यहां तक पूरा टाइप करा दीजिएगा. A plain reading of nature of injuries shows that there were multiple injuries on the person of deceased and cause of death was excessive bleeding. As per autopsy report bracket में exhibit P22, the Swami Prasad died because of injuries on his lungs and because of excessive bleeding. it was made clear that the cause of death, the reason, the death is homicidal in nature, was made clear that death is homicidal in nature. Next में the in view of aforesaid discussion, it is clear that the appellants with common object assaulted Swami Prasad, because of which he died. Thus, on the basis of evidence on record, in our opinion, the prosecution could establish its case beyond reasonable doubt. The court below has considered the evidence on the basis of permissible parameters. No perversity or illegality could be pointed out. In appellate jurisdiction, if court below has taken a plausible view, this court is not obliged to interfere in the judgment. Next, in view of accordingly, we find no reason to interfere in the impugned judgment of conviction. Resultantly, the judgment dated 30/8/12 is affirmed. The appeal is dismissed. Is anybody else ready for final hearing? Call kari.
Decision number 2.
Yes, anybody ready for final hearing?
Item number 69.
Ready है government.
सर सो रिक्वेस्ट नहीं किया था तो अभी है नहीं सर असाइन नहीं किसी को 60
तो कल तैयार रहिए 69
मतलब 69 and 71.
69 and 70.
71.
69 and 71 नोट कर लीजिए मिस्टर अरविंद सिंह.
71
हो गया. Anybody else? Anybody else?